that are going to be presenting today. Do we have any apologies? On my side, I have one apology from Ms. Honorable Janche, who is attending the Magistrates Commission. Honorable Engelbach.
Thank you, Chairperson. I have apologies for Honorable Vaughan and Breitenbach.
Thank you very much.
Advocate Breitenbach is, I think, en route to Cape Town, so she's on an aeroplane somewhere at this point in time.
Thank you very much, Honorable Engelbach. Any other apologies? None. Can we now invite the NDPP to make opening remarks?
Good morning, Chairperson and Honorable Chairperson and members of the committee. My name is Rodney de Kock. I'm the Deputy National Director of Public Prosecutions. I note an apology on behalf of the NDPP. She's currently abroad. I'm currently acting as the NDPP in her stead. And so I've been mandated to present the presentation to Parliament if that finds favor with you, Chairperson.
Thank you very much. You are welcome, Advocate de Kock.
Thank you very much, Chairperson. Chairperson, I have some officials of the MPA present on the platform. There is Advocate S. Singh. She's the TRC National Coordinator. And then Advocate M. Mahaga. He is the Special Director in the Office of the NDPP. I also have Advocate Belelwa Mekeke. She's the Head of Communications. We also have some DPPs who are actually seized with the TRC matters in the divisions present on the platform. If we can move to the first page, the contents page. This will be the scope of the presentation. We will speak a bit about the dedicated capacity. We'll talk a bit about the monitoring and evaluation and the progress in relation to the investigations, the matters that are enrolled, and some matters that have been finalized, and then some closing remarks. Move to the next slide. The members of the committee, since the presentation to the committee on the 1st of June, we'd like to report the following progress. We want to note that there has been some substantial progress in relation to the management of the TRC matters. In respect of the dedicated capacity, we have increased the dedicated capacity, both in terms of the investigators and the prosecutors. We've also, since the last meeting, have various engagements with the families, and the committee will recall that we were specifically requested to engage more with the families, and we've enhanced our engagement with the families. An internal communication was sent to all the directors of public prosecutions by the NDPP's office. We've had engagements with the DPPs and representatives of the apartheid era victims family group, as well as other stakeholders. We have also increased the MPA DPCI TRC accountability sessions held within our divisions. Now, these accountability sessions are meetings that we've agreed with the DPCI and our directors of public prosecutions to hold with the National Office of the MPA, where we specifically deal with progress and challenges that are made in respect of the matters being dealt with at the provincial level. So colleagues of the National Office, including myself from time to time, are visiting the provinces to ensure that we are tracking progress of these matters. Between September 2021 and April 2022, 38 new investigations were opened. And between May 2022 and October 2022, an additional 32 new investigations were opened. In September 2021, 59 TRC matters were under investigation. As of October 2022, 64 new investigations stemming from TRC matters have been reopened. There's thus a total of 129 cases that are presently under investigation in different stages or in court. Chairperson, Honorable Chairperson, and members of the committee, we wish to bring to your attention that the initiatives that the MPA has taken in dealing with the TRC matters and that are summarized in this presentation are in line with the commitments made by the MPA stemming from the Rodriguez judgment and communicated to the Honorable Minister of Justice and Correctional Services. They all relate to our internal capacity, the processes and broader efforts to insulate the prosecution of TRC cases from any suggested or perceived political interference. We had submitted a detailed memorandum to the Minister of Justice a few months ago, wherein we set out in quite some detail the measures that the MPA has taken in relation to the processes and what it is done to ensure that TRC cases are receiving the requisite attention and that TRC cases will be fast-tracked within the work of the MPA. In addition to the enhanced capacity and stakeholder engagement, the MPA will also appoint a senior counsel to assess whether the measures it has adopted are adequate. If they are not, senior counsel will make recommendations to strengthen them. So this is a mechanism that we have put in place to ensure that we can speedily attend to any criticism that is still leveled at the prosecution. And we have appointed outside counsel that will act independently of the MPA and of the NDPP in particular, that will review this work. The counsel that we have approached is someone that has worked closely with the TRC matters. I'm not at liberty to disclose the name at this point because I'm not sure whether the person has actually been appointed or not. And that's being dealt with through our administrative offices. But we want to ensure that whoever is assigned with one or two additional lawyers to assist will be in a position to understand the nature of the TRC work, the scope of the work, and will also understand what is required by South Africa to advance this work. And so we will appoint someone that's really got actual knowledge of the work of the TRC. In the process of review, senior counsel has reason to believe that there is information amounting to the violation of Section 41(1) of the MPA Act. Such issues will be escalated to the NDPP. If necessary, the MPA will refer matters for criminal investigation. So members of the committee will remember and recall that in the Rodriguez judgment, there was criticism leveled at the prosecution in relation to so-called political interference. So what we are suggesting by this part of the work of the senior will have to be that if there's any suggestion that the interference was of such a nature that it may amount to criminal misconduct, that will then also be referred to the NDPP and further action will be taken. So we're leaving all of that into the scope of the work of senior counsel and the counsel that's appointed. The missing persons task team, in addition to recovering the remains of 179 persons, also has recorded successes amongst others. The location of the remains of an MK member shot in 1980 which excavation is currently being planned, the identification of a burial site where 4 missing NK members were ambushed in the Caprivi Strip in the 1970s, and the recovery of the remains of a political prisoner, Mr. James Boy, who had been buried in a pauper's grave. His remains will be exhumed and presented to the family for reburial, which took place on the 30th of July 2022. So the work of the missing persons task team continues, and we believe that this is an important institution within the NPA to bring closure also for the family and the victims of the apartheid offences.
Sorry, Advocate de Kock.
Yes, sir.
Is under location of the remains of an MK member shot dead in 1980. I'm not sure why are you not saying who that MK soldier was, because you are able to identify the recovery remains of Mr. James Boy. If you can tell us the location, the identification of a burial site where 4 missing MK members were ambushed.
Yes, so you want the identification of the actual site?
No, the names, I think, because I think there is no reason to not to disclose them. You've already disclosed.
Oh, the names. Yes, we will. Yes, we will come back with those names at the end of the presentation. I'll ask the colleagues to assist to get that information in the meantime. Thank you very much, Chairperson.
Thank you.
If we can move to the next slide. We now move to the dedicated capacity, just to demonstrate to the committee where we are currently. This is a continuous process. As the work increases, we also look to increase the relevant resources. So as far as the MPA is concerned, we have a total number of 25 prosecutors assigned. What is important to note about these 25 prosecutors is that they work as a cohesive unit, a national unit, although they're placed in the divisions of the prosecution, and they only do TRC work. That is an absolute prerequisite. They don't do other work. And that is why we are now able to demonstrate such progress in relation to the investigations and the work we're doing. So there's the breakdown of the provinces, as you can see, and this is also a reflection of the work that's happening in those provinces. KZN at the top with 5, DPP Eastern Cape currently, we have 7 prosecutors assigned, and we'll see Gauteng, we have both Gauteng divisions, we have 6, Western Cape 3, Limpopo 1, Northwest 1. As far as the dedicated capacity of the DPCI is concerned, there are 40 investigators. The same principle applies, that they are only assigned to do TRC work. Of course, what you don't see in the picture is the management components and the other support functions. So these people don't operate in isolation. There's other support that's around them in terms of getting the work done. The DPCI has organized themselves into different regions: Central, Coastal, Eastern, Western Cape, Western and Karoo and Northwest. And on the right-hand side, we see the breakdown of the figures: 19, 7 in the coastal region, 8 in the eastern region, 4 in the western region, and 2 in the Karoo region. If we can move to the next slide, colleagues. The monitoring and evaluation and the progress made in relation to investigations. Honorable Chairperson and members of the committee, this is the current status of the matters within all the divisions of the prosecution. And again, just to emphasize that the work happens under the supervision of a director of public prosecution in each of the MPA divisions assigned to each of the high courts. So in the DPP Western Cape, there are 9, Free State 2, Mthatha 11, the broader Eastern Cape 14, Northwest 5, KZN 29, Mpumalanga 5, Northern Cape 3, GLD, Gauteng Local Division, that's Johannesburg, 25, GDP Gauteng Division, Pretoria, that's Pretoria office of the MPA 16, and Limpopo 10. That then arrives at the figure of 129, the total matters within the division. We can move to the next slide, please. Internal communication forwarded to the divisions to encourage active engagement between prosecutors and family members or their representatives. This is what I spoke about in the introduction. Family members are kept up to date and report backs are received from the national office on a monthly basis. So we get report backs from our division at the monthly basis, also about engagements that are held by the DPPs with family members. Successful engagements were facilitated by the national office with representatives of the apartheid era victims family group and the respective divisions. This was rolled out to the GDP, the Pretoria office, and the Johannesburg divisions. And we also secured the attendance of the directors of public prosecutions in those meetings. Now, this is very important because the director of public prosecution is the most senior representative of the prosecution in each of the divisions. So who else were in those meetings? The dedicated TRC prosecutors, the dedicated investigators, the DPCI heads, and these meetings have taken place in October and November respectively. What is significant about these meetings is that here there's some explanation about where the progress are with the cases, where there are particular challenges we can engage, and we also receive feedback from the affected families or the representatives of those families. So we're trying to strengthen the communication processes, and we're trying for all of us to work together to enhance the way in which we do the work. So this is just a breakdown of the numbers that were present in those meetings. We also indicate that continuous stakeholder engagements will continue, and we also have scheduled for December 2022. If we can move to the next slide. So as far as the evaluation of the work that happens in the divisions, like I've indicated, we demand monthly reports from all of our divisions. The monthly reports are received in respect of all of the matters that are under investigation in the divisions. Detailed reports are submitted to the national office. The divisions are encouraged to identify challenges and where we need to intervene to identify the interventions that we need to make. Divisions have self-imposed timeframes, and this is just how you should work. When you are dealing with an investigation, it shouldn't be open-ended. You should be able to identify tasks that needs to happen and by when those tasks are happening. So it's done in a project management basis, and in that way you are able to hold everybody accountable. The legal and administrative challenges are addressed by our national office and our national coordinator. As far as accountability is concerned, the MPA and DPCI accountability sessions, we've noted that already. Here is where we actually discuss the details of each of the matters and the details of each of the investigations. So it's a collective approach where we can benefit from the wisdom and the experience of everybody in the room. So in each of the divisions, all of the prosecutors, all of the investigators that are assigned to the matters are then engaged on each of the cases, and that is where we can share best practices, where we can also understand what work still needs to be done, and where we can also collectively engage with each other to see how we can overcome certain challenges that arise in each of the cases that we are busy with. The dockets are then constructively critiqued and assessed in terms of the quality of what we are doing and the quality of our investigations. And so the divisions that we have done this in thus far is KZN. We've actually had 2 sessions in KZN already. There's significant amount of work in KZN. Cape Town, Northwest, and the Eastern Cape, where there's also significant amount of work. So we've had sessions with all of those colleagues. And of course, our national office is involved in this process, and we actually lead the discussions in terms of what needs to be done. So we will continue with this into the future. If we can move to the next slide. It's just a breakdown of who attended those meetings. I'm not going to go to all the details. Then follow-up accountability sessions will be held on a quarterly basis. And we are all encouraged in terms of planning in respect of the other divisions. Divisions with larger volumes of matters, as I've indicated in the introduction, will receive additional prosecutors. If we can move to the divisional progress. To date, there are 129 TRC matters under investigation, as I've indicated. 64 investigations have been reopened. The highest volumes of TRC matters have been reported in the following provinces: KZN 29, GLD 25, Eastern Cape Makanda 25. If we can move to the next slide. Just to remind the committee, this is at a very high level how we try to track progress in each of the matters. We divide them up into those respective categories, and we then try to focus the work in this particular way. So as we speak, in 64 of the 94 matters, statements have been obtained in category A. Witnesses have been traced, exhibit dockets and records of inquest have been sought, and some have been obtained. In most matters, families have been informed where traceable. 56 matters occurred between 1980 and 1989, and 27 of the matters occurred between 1970 and 1979. Of course, the older the matter, the more difficult it is to obtain the relevant evidence in relation to those matters. If we can move to the next slide. Chairperson and members of the committee, the next few slides indicates the matters that have been enrolled thus far. The inquest of Mr. Ernest Tipali, the arguments were heard on the 1st of November 2022. The judgment is outstanding. The State versus Rarich and another, the COSAS 4 matter, the judgment is awaited in relation to a condemnation application of SAPS in respect of legal costs. The accused are still to plead in this case, so they are trying to resolve their legal representation with the South African Police Services. The inquest of Dr. Haffajee, the arguments have been heard on the 18th and the 19th of October 2022. The inquest judgment is outstanding. The State versus Kutsia, this is the matter of Simlani. The outcome of Section 79 assessment is awaited. The accused must still plead in relation to this matter. The lawyers of the accused has indicated to the court the accused is not able to understand the nature of the proceedings and hence the Section 79 assessment. State versus Marais, the accused appeared in the regional court. A legal opinion has been obtained. In respect of this matter, the accused must still plead. The inquest of the Dr. Abdullah.
Sorry, Advocate Cook.
Yes,
In the matter of States versus Mr. Nyoka, what is the legal opinion all about?
I will come back to that at the end of the presentation, Chairperson. I'll ask the coordinator to explain what that is. Thank you.
Thank you.
Dr. Abdullah Arun, this inquest has commenced in the High Court in Cape Town. All the evidence has been led. The matter has now been postponed for argument, and this matter we've made significant progress over a very short period of time. We're happy to report that this matter has received quite a lot of positive attention in terms of the way the MPA has dealt with the matter. Ms. Nkubeka, inquest proceeded on the 24th of October 2022, postponed to the 30th of November 2022 for the outcome of legal representation. Mr. Sibo Pewa, the inquest was on the 24th of October, postponed for the 30th of November 22, outcome of legal representation. And Sama Sokolu, inquest proceeded on the 24th of October 2022 at Mlazi, postponed till the 30th of November, outcome for legal representation. James Nkomba Zulu, inquest on the 7th of November 22 in Pongolo, matter postponed for outcome of legal representation. If we can move to the next slide. In Gauteng, State versus Rodriguez, that matter, the accused passed away on the 7th of September 2021. The charges were withdrawn. The inquest of Dr. N. Agate, the previous verdict in relation to this matter was overturned on the 4th of March 2022. And Mr. Paris Manaki, the deceased was shot and killed by Sergeant Van As at the Protea police station. He was convicted of...
Sorry, Advocate de Kock.
Yes, sir.
In this one, the Agate case, for the benefit of those who are watching at home,
yes.
Can you explain the verdict overturned?
And then, so the original verdict would have been that there was no one responsible for the death of Mr. Agate. The new verdict would indicate that members of the security forces would have been responsible. I'll also ask the coordinator to give the direct verdict in relation to Dr. Neil Agate as well. Setembele Sokwe in the Eastern Cape, death in detention. The two security branch police officers were convicted in the former Transkei of murder and sentenced to 20 years imprisonment on the 25th of November 2005. So, Chairperson, what we've done here is there was some of this information that was not available previously to the committee. We have gone through all of the records at our national office, and some of these matters we've identified were in fact finalized. And as you can see in this case, it was 2005. So what we are doing is just to make sure that all our records are accurate in relation to all previous matters that were dealt with by the prosecution and the investigators. So some of the matters are then thus older. They were finalized some time ago. Mr. Eric Mtongo, death in detention as well. The accused were tried and convicted in March and September 1989 for the death of the deceased. They sentenced to range from 2 years to 12 years imprisonment. So this case was finalized some time ago. And then Mr. Goodwill Colin Sekahana, all suspects were granted amnesty. The decision was taken not to prosecute in relation to that particular matter. And then Mr. Peter Tabukeleka, all suspects were also granted amnesty. The decision was taken not to prosecute in that matter. If we can move to the next slide. These are some of the older matters that we thought we'll bring to the attention of the committee as well. State versus Freddie Barnard, the murder of Dr. Gordon Webster. It was life imprisonment was in relation to that matter. The State versus Eugene de Kock was also linked to TRC-related matters. As we are aware, Eugene de Kock was convicted of multiple offenses of murder, fraud, etc., and sentenced to 2 life terms imprisonment plus 212 years imprisonment. State versus Gideon Nieuwoud and 2 others. The Motherwell bombings, he was sentenced to 20 years imprisonment. We are aware of the matter of Wouter Besson that ran in our courts, went all the way to the Constitutional Court. He was acquitted. State versus Magnus Malan also led to an acquittal. State versus Kwesi Nkomo and others. There was a plea bargain in relation to conviction and a suspended sentence done at the time. State versus Aaron Tiani and another was convicted and sentenced to direct imprisonment. State versus Eugene de Blanche, convicted and sentenced to 6 years imprisonment, wholly suspended. And State versus Blarney, convicted and sentenced to direct imprisonment. So this is just some of the older matters. And like I've indicated, Chairperson, we will not necessarily report on these matters again, but it's just to bring to the committee some of the more details in relation to all the TRC matters. We are making great efforts to be sure that we are dealing with all matters that would qualify under this TRC, and thus we are doing our best to look at all the records that we have currently. So in conclusion, the hard work and focused close collaboration between the MPA, the DPCI, the victims and their representatives are bearing fruit. The monthly monitoring and evaluation of progress on all 129 interventions are implemented to support the divisions. The culmination of interactive DPCI MPA accountability sessions are ongoing, and this is where we also ensure that there's a skills transfer. The constructive participation between the stakeholders and the victim's family is something that we have strengthened in the interim, and we know more progress is expected, and we are committed to delivering on this commitment. The challenges that still include the age of the matters, the age of witnesses, persons of interest, suspects, destruction of records, including inquest records, and no trace of dockets, exhibit, etc. These are some of the challenges that we are faced with. The committee must be aware that some of these records may have been deliberately destroyed, and it makes it very difficult for us to investigate those cases. If we can move to the last slide. It's just a presentation of some of the media attention that the TRC matters are getting. I think that is all from our side. Thank you very much, Chairperson. I'm going to ask the coordinator to answer your questions in relation to the names that you raised previously, the legal opinion, and then the outcome in relation to the inquest of Dr. Neil Agate. If I can just ask my colleague to respond to those 3 aspects. Thank you.
Thank you very much, Acting National Director, Advocate Tukok.
Chair, committee, good morning. Can you hear me?
Yes, we can hear you. Morning.
Thank you. Thank you. Chair, in respect of the legal opinion that was requested, Thank you. In respect of the legal opinion that had been requested, we had experienced that in quite a few of the matters where the accused were represented and where the deceased family were represented by legal representatives, there had been a request to add additional charges of crimes against humanity. In particular, these arose in the matters of State versus Kutsia, in the Simelane matter, in the Kosaspo matter, and in the State versus Roddick and other matters. Previously, legal opinions had been obtained, both from the legal representatives of the family and also from members within the NPA. We were of the view that we required an independent and external legal opinion And that is the reason why we asked for an external legal opinion. In particular, two issues were raised. One was whether Section 232 of the Constitution introduced customary international law retrospectively, or only from the date on which the Constitution came into effect on the 4th of February 1997. And two, whether Section 35(3)(I) can be relied on as sanctioning of a prosecution of customary international law offenses from the time when they acquired customary international law status, or whether the provision is simply a reference to Chapter 4 of the Constitution. On the 10th of October, 2022, an external legal opinion was obtained from Professor Stradon from the University of Johannesburg. We are in possession of the legal opinion, which must still be circulated throughout the divisions to give them direction as to how to proceed with the requests by legal representatives. In respect of the Agate matter, Dr. Agate was a medical doctor. He was also a trade unionist. He was taken into custody at the end of 1981 by members of the special branch. In 1982, he was found hanging in his cell. There was an inquest that was initially held, which found that he had committed suicide. And when the application for the reopening of an inquest was made, the court found on the 4th of March, 2022, that Dr. Agate, in fact, did not take his life, but that he had been killed, and that there were certain members of the security branch that had been directly implicated in his death. And that is the reason why the second request had been reopened. I think that I answer the question of the chairperson.
Advocate, seeing just the names of those members, those MK comrades that was mentioned earlier.
Certainly, Chair. So in the incident in 1970, referred to the names of the following deceased. It was Flag Boshielo, Theophilus Mkalipi, and Faldini Mziwonke. The fourth member was not shot dead in the ambush. His name was Benay Indezaku. He was captured and we believe was later murdered by the South African security branch. Regarding the comrade, the MK cadre in 1980, we have three possible identities, and that is why the DNA samples have been taken from the remains. It could either be Walter Shandu, Abel Boshomane, or MK Square. We are still waiting for the outcome of the DNA results. Thank you.
Thank you very much.
Thank you, Honorable Chairperson. That's all from our side. Thank you.
Thank you very much to the NPA, led by Advocate de Kock. Members, that is the presentation from the NPA. Are there any questions or comments? I have the following hands. Honorable Hanif Hendricks, Honorable Polangola, Honorable Stephen Swart, Honorable Nivut Johan, Honorable Maseko Jele, in that order. Honorable Hanif Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, I think that there has been substantial progress since the National Public Prosecutor appeared before you, and there was an undertaking that resources will be ring-fenced from the budget, because the excuse has always been over the last 20 years over different ministers that there's no money to carry out the instructions of the TRC, that these over 1,000 victims that have been accredited, that inquest must be, in many cases, reopened. We would like to know if there's an actual ring fencing of resources, because we don't want Advocate Rodney de Kock to come with excuses when he is summoned again that there is no money, because we're only now dealing with 10% of the cases, and there's still another 900 cases. I am very concerned that the National Prosecuting Authority wants to play God. They can't decide that because there is witnesses have died, that the inquest won't be reopened. The TRC ordered that it be reopened. And I'll tell you why, Honorable Chair. Dr. Agat did not take his life. That brought a lot of relief to the family. Imam Harun did not fall on the steps or committed suicide. That brought a lot of relief to the family. In the case of Chief Albert Atuli, he did not commit suicide or unintentionally walk on the train line. But the Atuli family, when we brought the Hawks to Al Jama's constituency office in Stanger, was told by the Hawks that here is the file, here's the docket. There's no evidence in here that we can take Chief Albert Atuli's case forward. That is wrong, because if the family members had a chance at an inquest to state their case, even if they were the only witnesses left that could be found, you know how much relief that would bring to the family that their side of the story was heard. Do you know, Mr. Chair, how much relief it will bring to the nation to hear that this great leader did not commit suicide or walked on the train line because he was not of sound mind? So it is very important that the TRC, that the National Prosecuting Authority should deal with every case that has been referred by the TRC. They can't just shut the door to unilaterally to families. They can't play God, Honorable Chair. They have to listen to every case. And just to conclude, Honorable Chair, in the case of Imam Harun inquest, we heard how the docket showed that there were bruises on his body. When they opened his skin, there were bruises under the skin. When they looked at the muscles, there were bruises in the muscles. When they looked at the bones, some of the bones were broken. It shows how people were tortured by the Afrikaners in those days, by the special branch. And the message that can be learned from the Imam Harun inquest is for those that oppress us to understand how we were harmed, how our loved ones were hurt. And because these cases are not heard, you find that these people, with respect, still want to return to apartheid, still want white rule, still want all of those things, and they don't want to apologize. They don't want to pay reparations. And I put a question to the minister, asking him why these special branch people, their pensions should not be forfeited, and why their widows and children, their pensions should not be forfeited. I also want to know from Advocate Rodney de Kock, why is he not answering the question I put the minister? 3 months now, the 1.8 billion rand for survivors of families of these atrocities. There are no plans to disburse the money. There are no strategies to guarantee that the monies won't be looted. And there are no policies to give the new head of the TRC unit the capacity to carry out given to the unit. So while we applaud the progress that has been made, we are not really impressed. There is much more work to be done. We need to show more implementation of the recommendations of the TRC so that Bishop Tutu does not continue to turn in his grave. Thank you very much, Honorable Chair.
Thank you very much, Honorable Hendricks. Honorable Ngola.
Ngosi Sihlalo. Please allow me to have my video off. I'm in transit between Western Cape and Eastern Cape. Chair, let us welcome the progress report in respect of the TRC cases, and equally let us welcome the additional capacity in terms of prosecutors and investigators in ensuring that these matters are brought to completion, because we all understand that the longer they drag, the longer few chances of us acquiring sufficient evidence for prosecution, the longer the chances become very minimal. I see, Chair, that they have segregated it into divisions, and they have assigned a number of investigators and prosecutors into various divisions in line with the number of cases that are investigated in those particular divisions. But I want to check first, Chair, that have they deployed investigators and prosecutors in those various divisions in accordance to the number of cases that are assigned or designated into that particular division, Chair? Another issue, Chair, that I think Mr. Hendricks has touched a little bit is the issue of the funding or the resource capacity of the NPA to pursue all these apartheid crimes. If they can tell us specifically how much is the budget to pursue these crimes. The second question, Chair, would Advocate de Kock says there are 129 cases active. Inclusive to that are 64 new cases. Now the question would be, can they confirm that they have traced all the 129 families and those families are cooperating with the investigations? There is another issue, Chair, of time frames, which I think it is in line with the fact that these are old cases and all that. Witnesses perish because they are old and all those things. Now, Advocate de Kock says there is a self-imposed time frames from various divisions. Apart from that, does NPA have a particular time frame at which they estimate that these cases would have been completed, all of them or almost all of them? There is a case, Chair, I think, I'm not sure if it's a case of Blackie or something, a case where a particular sergeant shot and killed this victim, but the court granted, I think the court acquitted him or something like that. So I would like to get more detail on that effect. What happened? Was it on the basis of the lack of sufficient evidence? What were the actual legal problems regarding the unsuccessful prosecution of that particular sergeant? I think, Chair, my last point would be, I think let's equally design as the committee a monitoring tool to monitor the progress of these prosecutions and investigations, which I would suggest that at least each and every quarter we must have a progress report meeting in respect particularly to these TRC related crimes. Thank you very much.
Thank you very much. I think, Honorable Mola, you were in New York when we took that decision as part of your oversight in another committee, international relations, but we have already taken a decision that we are going to be having quarterly meetings. So this meeting is as a result of that decision, that every quarter there is a progress report that must be submitted to the committee. Thank you very much.
And those opinion in New York,
Thank you very much. Honorable Stephen Swartz.
No, Chair, thank you. I appreciate the progress that has been made. I appreciate the submission by Advocate de Kock. I think it's always important at the outset to repeat what was said in the full bench in the Rodriguez matter, that society as a whole has an ongoing interest in the work of the TRC and the follow-up that the government had committed itself to, and that Parliament, which represents the legislative authority of the state, has a right to know when the letter and spirit of legislation that it had passed was being deliberately undermined. And I think that brings me then to appreciate the role of the committee in exercising oversight. Obviously, we need to be very cautious that we as politicians cannot intervene in any way in the exercise of discretion by the NPA. That would fall foul of Section 41 of the NPA Act. Clearly, it is up to the NPA to evaluate evidence and to decide on prosecutions. They are exercising their discretion, their prosecutorial and independent discretion, and in my view, are not acting as guardian in any way, but are exercising a legally given discretion, which in itself is reviewable by high courts. I think it's very important also for us then to just establish, given what was said in the Rodriguez matter and the concerns of political interference, whether progress, and let me just rephrase that. Advocate de Kock did say that there's a process of appointing a senior counsel to assess whether the matters had been properly dealt with, and that and there's an admin process that's ongoing there. I think we need to have further briefing on this, because at the time of the minister's briefing, he indicated some form of inquiry, and is this, and we'd need possibly the minister to advise us, is that inquiry separate to what is anticipated by the appointment of senior counsel? But then as far as the appointment of senior counsel is concerned, I do appreciate it is a process, but we were told at the last briefing that senior counsel was to be appointed, and it's a bit concerning that it seems that senior counsel is still not being appointed, and that if one has regard to the judgment in the Rodriguez matter that was given in June, or was it last year sometime, where the court wanted some form of investigation, maybe we need a timeline looking into that aspect. But we do appreciate that progress has been made with these matters. I would like to then ask on the one particular matter of the Kalata matter, the Craddock 4 matter. I appreciate that according to the briefing we've received, that the NDPP or the provincial representatives have been meeting with the families. And maybe, Chair, it might be important for some way that in future when we have these briefings, that families can also, where they would like to be part of these parliamentary hearings. I'm not sure to what degree families were alerted, and I know that in itself is a challenge, but it would be good if people that are involved, families that are involved that want to bring closure, are somehow allowed to be part of these, are informed when we have these oversight sessions, particularly as family members might say, but what is being told is not correct. And they are not happy yet. But I do appreciate and I accept the word of Advocate de Kock that there is a much better engagement with the families and we are seeing progress. But let us just make it clear that it seems that over the years, and we appreciate the renewed efforts, but it has only been as a result of the families' pressures and in certain cases, court applications that have obliged this process to be continued and the TRC matters to be continued. So can I get an understanding? I understand there was a civil matter in the Craddock 4 matter related to the delays with the criminal prosecution. Do we have any idea what has happened with that civil matter? Has it been finalized? Hopefully it's been held in abeyance because there's been good progress with that matter. But I think we would also like to know when a final decision will be made in that regard as well from the NPA's perspective. I do appreciate what the NPA has said. Problems with records, problems with evidence. This goes back a long time. But I also just want to add the issues that my colleagues raised about the issues of budget. We note that there are significant allocations of resources, and is this within the broader budget framework? And whilst these issues are very important, to what degree do they impact on other matters that the NPA has to deal with, such as the state capture matters, such as a plethora of other matters, the gender-based violence matters we're faced with at the moment? Is it, how do the prosecutors manage to the heavy workload that they're faced with? And I appreciate these are designated prosecutors that are dealing with these matters. Then can I just, on the Rorich matter, Rorich, R-O-R-I-C-H, there was an application for legal proceeding, legal representation, and that was granted by the courts, and now there's an appeal, and I understand that the court has in hearing the appeal, or at some stage the court was most upset with the approach by SAPS in the delays, and that there's a possibility even, and this was according to media reports, so one doesn't know to what degree this is so. One would like to actually hear directly from what the court said, but just delays with process filed by, one presumes, the state attorney in those issues. SAPS representatives missing court appearances and possibly even facing contempt of court rulings and punitive costs purely on an application for legal representation that seems to have been delayed, and where judges purportedly indicated that in his 25 years on the bench, he had never been treated so contemptuously. So, Chair, we would probably also need to look into this, and it seems to go to the representation from the state attorney's office or whatever. Maybe the state attorney didn't get instructions properly, but this obviously adds to extended delays in these matters. Then, Chair, I would just want to have a look here, the issue related to, I've covered the records issue. Yes, Advocate de Kock did indicate that a number of the records going back might have been destroyed. This is a challenge, and with witnesses. And I think, Chair, I appreciate also that there will be ongoing oversight from the committee on a quarterly basis. So I'll leave it at that stage. Thank you, Chair.
Thank you very much, Honorable Swart. Honorable Nieuwoudt, Toegang.
Thank you very much, Chairperson. Good morning to everyone on the platform, and thank you to the NPA and the team for the presentation. I am quite happy that you have committed to continue engaging with the families, because I cannot imagine how the families must feel with all the years where things have not been investigated, there's no closure, they still feel the pain of the questions that have gone unanswered on how their loved ones have died and what happened. So I'm very happy that you are committed to meet with the families. I have two questions, in terms of two areas. Number one, the numbers that you presented the TRC referred 300 cases to the NPA. And the NPA said that they are now busy looking at 129 cases, which leaves 171 cases that was referred. So now I want to know the new cases that you mentioned, the 64. Is it 64 of the 171? I just want to understand the breakdown of that. So then, you know, how much is then still left to do? And will you still be investigating those that are left until the 300 that was referred is completed? That's my first question. And then my second question, Honorable Swart asked about this, but I have a specific question with regard to the the Rorich case, where SAPS refused to pay the legal fees. And I want to understand this now. The NPA did the investigation, and if it goes to court, then who pays the legal fees? I'm not expecting that the families who are grieving and who want answers to be the ones to pay the legal fees. That part is, I just need a better understanding in terms of this. Then I also want to know what support, whether it be financial or any support, does the NPA provide the families for this, you know, to go to court? Because I want to understand the legal fees part, because it says that SAPS refused to pay and the family appealed. So, you know, I have questions. If the family, you know, can't pay the legal fees, does this mean that the channel for getting answers from the court then is blocked? Just need to get a better understanding of that. Thank you, Chair.
Thank you very much, Honorable Nibot-Trochen. Is Honorable Jelle still part of the meeting? At some point,
yes, I'm still part of the meeting, Chair.
Okay. Thank you very much.
Thank you.
Hand was, yes.
Thank you, Chair. And if it cuts me, because it keeps on cutting me, just continue with the meeting, Chair, and because most of the questions are covered. But I wanted to find out, especially on the issue of the missing persons, Chair. We still have a lot of people who are missing, except the ones that they have just, they are recovering right now. But I think in one of our meetings, or is it the last meeting? I'm not sure, but if it was not mentioned, I was going to propose, Chair, that this issue of the missing persons, we have a special meeting, even if it's short. Can we get that team that is working on these special people? Because there's a list of those people, Chair, a list that is coming from the NPA. But if I'm not mistaken, Advocate Batoy promised us a report on this and then also a presentation on this, only on this matter, because there are still lots of people, Chair. I think there are many families that are angry towards the government on this issue, Chair. So if maybe we can, even if within their presentations, but a special presentation on this matter. And then also, Chair, there's an issue. Chairperson, there's one honorable, I can't remember, who spoke about the issue of the evidence in terms of the postmortem, the bones and the muscles and all that. I don't know if maybe, Chair, because there are a lot of files that are missing, that makes these cases to be difficult to be closed. That evidence of postmortem, the possibility of really looking seriously into that evidence and assist to nip some of these perpetrators of apartheid, especially the special branch. And he also proposed that if the pensions of those special branch members can be something done with that, Chair, because where I am, I'm thinking about this. They are looking at us. We are spending a lot of money going up and down, trying to resolve these issues, whilst they are here alive and enjoying the benefit of democracy when they have caused a mess in the families. The families are crying, they want answers. These people, they don't bring answers. They don't assist us, but we are paying them for their lives to continue and enjoy out of the hard work of people of South Africa that are aggrieved. Chair. So on the issue of capacity, I'm covered, and the resources, Chair. We need to emphasize that one. I'm covered, that the other honorables covered that one. But on this issue of the courts, Chair, if I may ask, the courts, we are using the same courts that we have to deal with these issues of TRC. If I'm wrong, Chair, the committee will correct me. If we are using the same courts that are also heavily burdened by the daily issues of crime that we have experiencing in our country, how are we going to concentrate on and in fact make justice on these cases? Is it not time for us to propose for special courts, just special courts to deal with these issues, so that there is a focus? I'm just thinking, if it's not possible, it's fine, Chair. I'm okay, but I thought that maybe I must also reflect on that one. And then lastly, Chair, is on the issue of the memorandum. That memorandum that has been submitted to the minister, is the department still not having a response? And what impact does it have on the whole issue that we are talking about now? Thank you, Chair.
Thank you very much, Honorable Jele. Just a few quick ones. One is a follow-up on the issue that was raised by Honorable Swart about your engagement with families across the country. Now, my question is, if the CREDOC 4 family was contacted, why would Mr. Talata say that with respect to this decision on a civil case that was promised by the NDPP, they have never seen or never heard from the NPA, which means that they were never contacted? And let's say you have, why would he say publicly that they were not contacted? Or if put differently, did your engagement with the family cover that the imminent decision that you promised that you are going to make? That is number one. And then number two, with respect to the matter of Caiphas Nyoka, has the Director of Public Prosecution, I think in Gauteng, South, I think so, made a decision with respect to the charge of a crime against humanity? Because I think last time we were made to believe that a decision was going to be made with respect to the charge of a crime against humanity. If you can just take us through the issue of the CREDOC 4, because already there was a clear judgment, in fact, Judge Zitzman in the inquest that was done as to who was supposed to be implicated. I mean, I think that that inquest covered a lot of ground with respect to the CRADOC 4 and even identified the people who should be liable. Why is it taking so long? What are the hindrances with respect to the CRADOC 4 matter? And coming back to this issue of families, how were they contacted, these families across the country? And what mechanism have you put in place to show that as part of your monitoring, you are able to know what was discussed with those families, and also to be able to gauge the response as to whether the family, because this is a very emotive process, and we are not taking it lightly. It's very heavy on the families. It is also heavy on the investigators and prosecutors involved, to know also, as you are engaging with these families, whether they are able to, in fact, whether you are able to gauge to the extent that you are able to be able to take them on board, to see the efforts that you are making and the response from their side, some form of what we call a feedback mechanisms, whether your system do have that. So, but it would be important as to how you are able to identify those particular families as part of your monitoring and evaluation process. And I think I do like what you said on Advocate Dikok, that it will be the last time you brief us about some of the very old cases and some that were concluded even before NPA was established, like the case of, what is this case? The Matonga case. That from now on, you would be briefing us about the work that has been done since the NDPP, the current NDPP, took over. Because we do accept that at some point there was a lull, and the issue now is that we are running against time, and you are the ones now that are taking responsibility. That for measuring progress, we would want to know that since you took over, what has been done. I think if there would be much focus on that, the 1999, 1989, some of the 2005 cases, I think I'm happy that you say that you were just reporting them for completeness sake, but moving forward, you are going to be focusing on the work that you have started and that happened under your watch. Over to you, Advocate Dikok.
Thank you very much, Chairperson, Honorable Chairperson, and Honorable members. Thank you for the questions. We appreciate the questions that have been raised with us. At the outset, I wish to say that the commitment of the prosecution to deal with the TRC matters is taken very seriously. I'm personally responsible for this unit now, and we, with our directors of public prosecutions, we ensure that besides the mechanisms that we have already put in place, that's the operational mechanisms, I meet with the directors of public prosecutions on a monthly basis. So these are physical meetings, and there we then discuss various matters, the GBV, the corruption, all the priorities of the country, but the TRC is one of those priorities. So I want to reassure the members at the outset that that is the approach of the prosecution in terms of dealing with the matters. As far as the first question or the input of Mr. Hendricks, Also to reassure that the prosecution, we are not gatekeepers in relation to any of this. All of the work will be dealt with. The questions when we pose the challenges is just to give an indication of some of the difficulties we are having. But our objective is certainly to deal with all of the matters and to bring closure to all of the family members in relation to the work. So just to reassure Honourable Hendricks that each and every matter relevant to the TRC work will be dealt with by the MPA and by the investigators. And in each and every one of those matters, we will bring those cases to be reopened as far as inquests are concerned and present the evidence. So in relation to the evidence, where we have a particular challenge with evidence or evidence being destroyed, we will look at alternative means to present the circumstances relating to the death. So we have experts that will reconstruct scenes for us, and this is what is happening. We will look at post-mortem or records of post-mortems. Many of the doctors who did the post-mortems are long time deceased as well. And so we will get other experts to examine that evidence, and then they become witnesses in the courts. So there's various techniques that we are approaching, honourable members, to present evidence to the court. But of course, it is very challenging since the matters had occurred some time ago. So if I can go then to some of the other questions. As far as Ms. Kolo's question regarding the capacity issues and the budgets, we have applied to Treasury for a deviation to appoint the prosecutors that we currently have doing the work. So money was specifically allocated for that purpose, and there is a ring-fenced budget within the prosecution services for us to do so. We also understand that the DPCI have a particular budget that's been allocated. So this over and above the normal budgets that we have. What we're also doing in the prosecution, we have motivated for a permanent capacity to deal with TRC matters. So to answer the question also about the timeline, we anticipate that we hope to complete this work during a period of 3 to 5 years. But we, of course, are doing everything in our power to move the matters as fast as we can. And then a decision of the NDPP and the executive of the MPA is also that we will motivate to create a permanent capacity to deal with TRC. So that is work in progress. But it indicates that we will have a particular budget that will be ring-fenced for this unit or this component in relation to the work of the TRC. As far as some of the questions and the comments that Mr. Swart has made, as we have submitted a memorandum to the Minister to indicate the approach that the MPA is following in terms of the issues raised by the court in the Rodriguez matter. Now, the original proposal was that a panel be appointed to investigate. But after some serious reflection between the NDPP and the EXCO of our organization, it was clear that the court was actually directing the NDPP to do this work. So after some discussion, it was agreed that the work that we had already done to strengthen our approach to the TRC is part and parcel of the mechanisms that the NDPP has put in place to address the challenges arising from the Rodriguez matter, already. And so hence we have in the memorandum to the minister, we indicated the approach that the NDPP has agreed that she will follow in relation to this inquiry. It is an internal mechanism in the first instance, with the new leadership of the organization having put in place the arrangements that we currently have. So what are those arrangements? It's the dedicated capacity, it's the new processes that we put in place, what we've reported here to Parliament today. But then we say that we will then get this independent senior counsel to oversee the work that we have done and to provide a report to the NDPP. And of course, we will report on this to Parliament, most probably at the next quarterly meeting, to say what were the findings of the senior counsel and the team that he will put together to look at the work. So what we thought that this is a faster way to get this process behind us. What we want to reassure the committee about is, one, the independence of the NDPP and the independence of the prosecution service. So the work that we do will be done independently of any kind of interference. So that we guarantee. But we want to get this job done as fast as possible because it's in the interest of the country. And like the chair indicates, this work is long outstanding and therefore we need to be able to account for the work. And so we felt that this is a better way, a better approach than having to spend lots and lots of money on an inquiry that will provide a report in 2 years' time. So in a sense, the leadership of the MPA decided that we need to move faster on this. So this is where we are. Depending on the report of the senior counsel, that will be independent. And what the senior counsel finds may need some further investigation. And so we leave everything open in terms of that process. But in the meantime, we are saying nothing can wait, the work must continue, and we're engaging with the work. So the senior counsel referred to before was not the same senior counsel that we are proposing now. I think that would have been referenced in relation to the panel that was suggested previously to be able to do this inquiry. And so this decision now that we're speaking about now is a recent decision, is a recent memorandum that we submitted to the minister in which we've indicated this to the minister. My understanding is that the NDPP has discussed it with the minister, who has agreed in principle to the approach that the MPA is following in terms of this. But ultimately, what we want to do is we want to deal with all the issues as speedily as possible. Largely, the criticism of the court before was that there was a suggested interference in the work of the MPA. And the current leadership of the MPA is saying that we will guarantee that there's no interference in the work of the MPA in the manner in which it's going to do these cases. And I think the report of today demonstrates the progress that we have made over the last few months in terms of how we are dealing with the matters. So, Chair, I hope that that clarifies the issue. But to the extent that the committee would want any further report on that, we are happy to submit a written report in terms of that particular issue. I'd like to turn to the Rodriguez matter. There was a question raised around the legal representation in this particular matter. After some application by the by the accused for the SAPS to fund the trial and the legal representation, the court had made a ruling that the SAPS need to pay for the legal representation. Now, we have got no control over the decisions of the South African Police Service. And they have to decide on legal representation for members or ex-members of the organization based on the merits of each case where we bring an accused before court. So this is a standard practice in the police. My understanding is that the police opposed granting legal representation for this particular accused under the circumstances. But despite that, the court then ordered that the SAPs need to pay for that legal representation. And that is the issue. Now, I'm not sure if we can regard that as a delay. I think the SAPs are within their rights to determine whether or not they want to fund the legal representation for some of these people who are going to be brought to courts, who were policemen before, but may not be policemen now, and who were part of the security branches of the country doing unlawful activities. The SAPs have decided to take that decision on review. And again, I emphasize that that is the SAPs' right to make that decision. So we will try to expedite those processes. But that is my understanding of what is being dealt with as far as the legal representation in the Roderick matter is concerned. Chairperson, as far as the number of TRC matters that we've investigated, there's the reference of the 300 matters that were referred by the TRC to the MPA. Now, we are currently dealing with 129 matters. What we are doing is that we are going through the records of the TRC to identify exactly all of the referrals that have been made, and hence my comments earlier, Chairperson, to you that we are going into the old records of the organization to be sure that we've identified all of the matters that need to be dealt with. But out of what we've done so far, we have, and that is why I brought in some of the older matters. Some of those matters were dealt with, and some of those matters, decisions have been made not to proceed with those matters. So that balance of 171 that is referred to, in some of those matters, decisions have been made previously not to proceed with any of those matters. Now, all of that is subject to review. The approach that we have followed is, even if a decision had been made previously in any of these matters by any prosecutor, we are going to look into those matters. So hence I've indicated that this is all still work in progress. So as we identify a matter where, one, there may have been an inquest, but we're not happy with the finding of the inquest, or the family were not informed of the outcome of the matter, or a decision was made not to prosecute in the matter, we are then reviewing those matters internally, and that is why this list is growing as we proceed. But this is all work in progress, and this is also happening on an urgent basis that we're doing those reviews. I'm now turning to the question of the CRADAP 4. This has been an ongoing matter, and there was a civil application some time ago in relation to this particular matter, Chairperson, as you are aware. The Director of Public Prosecutions, Advocate Barry Madolo, has been in contact with the families and is also been in contact with the legal representatives of the families. He is with us today. I've requested him to give the committee a brief overview of the issues that you've raised, particularly the issue that if we are meeting with the family, why was there a comment in the media that the MPA is not meeting with the family? So I'm going to invite, with your permission, the Director of Public Prosecution in the Eastern Cape, Advocate Madolo, just to respond to some of those issues in relation to the CRADAP 4. I think this would be a better process in relation to this particular matter. Thank you, Chairperson. Advocate Madolo, could you possibly proceed?
Good morning, Honorable Chair.
Good morning, Advocate Madolo.
And good morning, all to all the honorable members, the NDPP, and my boss, Rodney Cook. I'll be very brief, Mkhiaz. I just want to confirm that the team, including myself, met with the C4 families, and that was around the 4th of November. So if there is any assertion that we did not, I think it must have been before we met. We met, we briefed the family fully. We raised a lot of issues with them regarding why there is a delay, what obstacles are there, you know, and how we're going to try to overcome some of these. But in addition to that, Honorable Chair, I want to also mention that we're meeting with the family again next week. I think it will be around Tuesday, I'm not sure. I think Monday, Tuesday next week, there is another meeting, a follow-up meeting. Because what we decided to do is to take the family into our confidence, work with them throughout this process, brief them even on the legal issues, you know, so that we are all on board, you know. So it will be an ongoing engagement. We're working with them until we reach a stage where we're saying, this is our final decision. That is all, Chair.
I think that's fine. That's okay.
Thank you. Thank you, Chair.
No, thank you very much. I think that is appreciated. Advocate Cook.
Thank you. Thank you very much, Advocate Madolo, for that input. I think what you also, and I did receive a written report from Advocate Madolo in relation to the Cradock 4 matter. As far as the ongoing question around the decision in this matter is concerned, Chair, Advocate Madolo is also in contact with the legal representatives, as I've indicated. They have asked for some additional time to give input into the investigation or certain aspects of the investigation. So that is currently under consideration as we speak. I'm sure that the colleagues in the Eastern Cape will soon be able to come out with a decision in relation to the way forward of the Cradock 4. Everybody is really, really serious about that particular matter. Then there was a question relating to the victims and whether all the victims and families have been traced. Our response to that is that as we speak, the majority of the victims and families have been traced. The process that is followed is that as part of the investigation, the investigating officers need to get in touch with the families and then find the families, and then we then set up meetings with the family members. So we have individual meetings with family members, which is correct, where you discuss issues pertinent to the matter and where you try and bring the families to a proper understanding of what is happening in the case, what the developments are in the case, etc., and where you can address any particular concerns that the families have. So that is a very sensitive process of engagement with families, but prosecutors are well trained to do this. All of our prosecutors, as part of their training, have particular skills to deal with victims of violence, etc. Where we identify that families need additional support, the MPA certainly will put that additional support in place for family members. And then we now also have a new feature where we have these group meetings. So here people are organized in groupings as well, and there's different groupings. And there we then meet with people in a collective manner. And so this is often where you will get views in terms of strategies, how we can adopt or adapt the way in which we work, how we can address matters legally in court. And the example that Advocate Singh gave earlier about the legal opinion is part of that kind of process. And the prosecution is open to that. But of course, we always say that once we've done everything in our power, we need to make an independent decision. regarding what we are going to do. And that is what the law demands of us. So we can't just take a case to a particular court because we're under pressure. But we will engage with everybody, take the views on board of everybody, and then we make an independent decision. Now, someone may still be unhappy with that. Lawyers may still be unhappy. The families may still. We can't guarantee that there will be happiness with every decision that we take. But then there will be a different and a separate process to engage. So what's that process? Because the directors of public prosecutions are dealing with this matter, so you had Advocate Madolo here. If the decision of Advocate Madolo is people are not happy with that decision, they then have the right to take his decision on review to the NDPP. So that is the first process that will happen. And we haven't had any of those yet, specifically in relation to the new process that we have now. So the families or the legal representatives will then bring an application of review to the NDPP, and we will then have to decide the matter at the head office. And if they are still unhappy with the decision of the NDPP, then they can approach the courts as well to review the decision of the NDPP. But of course, we want to avoid all of that. But because it's legal issues, it's very difficult issues, the chances are that there may be some matters or some decisions of the NPA that will be taken on review. I think, Chair, I need to cover the missing persons task team. There were some questions.
Before you go there, Advocate de Kock,
yes,
you made reference to the fact that majority of families have been identified. And so the question would be, how many are still outstanding? Because I think by the virtue of saying that a majority have been identified, it means that you know the total number, and on the basis of that, you're able to come to a decision that a majority has been identified.
Yes. So, Chair, with your permission, I think let us do that exercise properly. Get that information and then submit that information to you. I think so. My understanding is it's the new matters where we're opening new matters. That's why we don't say all, because some of the new matters we're still in the process of identifying. But I'll get confirmation of the exact number in all of the 129 matters we referenced today for the committee. As far as the work of the missing persons task team is concerned, Chair, we agree that if the committee wants a separate presentation on this, I'm not sure that the NDPP actually committed to bring that presentation before, but I'm not sure if there is going to be a decision for a separate presentation or whether we shouldn't do it in the next quarterly review, that we maybe do a more detailed exposition of the work of the missing persons task team, what they've accomplished thus far, the total number of matters they've dealt with, the ongoing processes, and then also maybe potential matters that they are still looking at, because I think that was what was at the heart of the issue. There are still family members who are unhappy that their relatives have not been found. So I think the more we communicate around this, more we understand where the needs are, that will be better. And the better understanding we have of the actual work that's happening, then we can also have a discussion regarding what needs to be done by the team. But just to say, this is a world-class team. We also work with international experts in terms of this. And I think South Africa leads the way in terms of identifying missing persons. So there's a lot that we can learn and share regarding the work of the missing persons task team. And at the next meeting, or if you want a separate meeting, Chair, you could, your committee could possibly just inform us about that. There was one question regarding the reparations. I don't think we've touched on that, but just to alert members of the committee, this is really for the Department of Justice and Constitutional Development. The MPA is not responsible for dealing with the 1.8 billion in relation to monies that's been set aside for reparation. We only have a mandate to deal with the decisions regarding prosecutions and the assistance on investigations. That's the extent of our mandate, Chair. Chair, if you must help me, if there are any matters that I haven't addressed. I did try to combine some of the questions into one and provide a holistic response in terms of the issues raised by the committee. But that is the presentation and our responses to the presentation. If there's anything that we haven't covered, we're happy to respond in writing as well, Chair. Thank you.
The issue of Mr. Nyoka, a decision by the DPP with respect to a charge of a crime against humanity.
So the MPA hasn't made a final decision in relation to the crimes against humanity. We reference the legal opinion that we only recently obtained. This legal opinion has been shared with the NDPP. We are still in discussion regarding that, and then a final approach will be taken. But it's clear already from our legal opinion that we have to do this on a case-by-case basis, Chair. But if necessary, we can give a more comprehensive response in relation to the detail of the matter you raised. I don't have particular knowledge of that particular matter, so I can get a report from the DPP on it. But as far as my knowledge nationally is concerned, we haven't made any decision to prosecute in relation to crimes against humanity in relation to that case. Thank you, Chair.
Thank you very much. Members, are there any follow-up questions or questions that have not been answered on your part? I think all questions have been answered and members are satisfied with the responses given. There are no follow-up questions. Thank you very much to you, Acting National Director, and all the members of your team who are part of us today. Indeed, I think the report that we have received today, I think it's welcome. We will be able to meet for a follow-up report in March. In that report, I think it would be important that we find a day, a whole day, because what we are trying to also do is to try and meet you once for many issues, but we have the whole day so that we don't have, so we would meet you for TRC. And then in that meeting, we must provide us with the list of missing persons as Honorable Jelle has requested. And then we will also discuss after that, after we are done with the TRC, then in that meeting, then we need to be joined by SIU and the Hawks to discuss our ongoing engagement with yourself on the matters relating to corruption, the engagement which is started with yourselves in 2020. It will be part of our continuous oversight. So it would be in March. And there was an issue also raised on the issue of separate courts. I think at this time, courts are not the problem. I think the bottleneck is with investigations and decisions to prosecute. So I think it will be premature to establish separate courts. Resources should be channeled to the Hawks and to the NPA. So after the work has been done, if there is a need based on what has been concluded for separate courts, I think we will discuss that at that time. For now, let's focus on the issues of prosecutions and investigations. Members, I would also suggest that, we just raise this issue of the SAPS, but from the reports we have and the response of some of the judges, not all is well. And that is contributing to delays. So it would be important that maybe in our next meeting, but we have a meeting where we can have an understanding from the SAPS to the extent that some of their decisions might be contributing to the delays. So it would be important that the National Commissioner be invited to brief us, because as Honorable Swart raised it, it's not as straightforward as Honorable Tikok, Advocate Tikok, you are answering it. There is some sloppiness on the side of the SAPS, and it is contributing to these delays. And I would suggest members that SAPS be invited to come and explain themselves, because part of what this process should be doing, it's not about only the NPA. We should be identifying blockages in the system that contribute to this system, to these cases not being resolved expeditiously. And we should, to the extent that those issues would fall within the jurisdiction of Parliament, we should try and unblock those blockages. If we cannot, we should refer them to the appropriate bodies to assist us and the country to make sure that these cases are finalized. As far as our records are concerned, Mr. Tikok, Advocate Tikok, the minister still has to update us on, because the last time he appeared before us, he was somebody who was supposed to have appointed a judge, and he had contacted a number of judges at that particular time. So if there is a change of attitude or a change in circumstances, this committee is entitled to be appraised of the reasons for such changes. And that would be, I think the minister also early next year would need to appear before the committee to explain that on his part, and because that is the last response that we have in terms of our own records. Now, if we just leave it hanging, then there will be something when people go through our records many years to come, it will come across as if Parliament did not do its work. So it will be important that he appears before us to brief us. But thank you very much for the hard work that has been put into the processes, the DPPs that are helping, the prosecutors that are engaging with families, the members of the SAPS, that is the Hawks, that are part of these processes. But it will be important also to as part of the backup system, if resources allow, to have regular intervals with both the police and the prosecutors involved to get psychological debriefing. It can be quite taxing emotionally. It can be quite taxing. I mean, you would remember when we had met us before the TRC, some of the commissioners would even break down. So these investigations are going to open serious wounds, and sometimes those soldiers on the ground, that is the police, the investigators, and the prosecutors, would need to be taken care of. But we think that all the effort, we are starting to see some lights. We are not yet there, but we are starting to see some lights. And I think one of the lessons that we should learn from this process, and especially from the delays as a nation, is that when you don't act on time, you are bound to act under unreasonable pressure. So we have pressures now that most of these people have died. We have pressures that some are going to plead that they can't follow proceedings. So there's going to be a lot of these things, and it's an indication that we should have acted earlier. And I think it's a lesson to all of us, not only to the NPA, it's a lesson to all of us. And then there is an important point that Honorable Hendricks raised, the issue of that 1.8 billion. It's important that maybe when the minister comes, he must bring the Director General along. That matter needs to be, we need to get a briefing on it. How is that money dispersed to our communities? We would need a detailed briefing on that. It's a very important issue to be left unattended to. Thank you very much, members, and thank you to everybody on the virtual platform, and special thanks to the NPA. This part of the meeting is adjourned. Can we have a 9 minutes break and start at 11:30 for hate crimes, hate speech bill?
Thank you very much, Honorable Chairperson and members. We particularly appreciate your comments regarding looking after our investigators and prosecutors. And those are well received. We certainly will look into that matter as well to put support from our EWP officers for the members concerned. Thank you very much for the time.
Thank you very much. Members, can we have a short break and come back at 11:30? Let's welcome the Deputy Minister, Honorable John Jeffrey, DDG, Ms. Pillay, Mr. Dupree, and Ms. Botha. Over to you. Can you take us through the recap?
Good morning, Mr. Chair and members of the committee and Deputy Minister. Mr. Chair, I would like to, and you are expecting most probably for us to go through the working document with you, and we are ready to do that. However, I would like to get your permission, please, that Ms. Botha just indicate to the committee by sharing the annexure that was attached to the research document that we presented the previous time. We have now included additional information, and we would like, with your permission, Mr. Chair, to highlight that to the committee, please.
Okay. We're in your hands.
Thank you, Chair. I just want to indicate the last time that we met, we spoke to additions that we've made to the annexure to Research Note 2. And I just want to go down to those additions quickly. They were under the grounds of birth, and there was one addition to the ground of language. Just going down. Here we go. So it starts, the cases that we've included on both starts on page 8 and it goes down to page 9. We've added 2 cases on both. The first you'll see is Wilkinson and another v. Crawford, NO and others. There's a little excerpt on that. And the other case we've included is Peterson versus Maintenance Officer and others. Like I say, these are the 2 cases that we spoke to the last time that we met, and which I indicated that I'd found on the morning of the meeting. So they weren't included in the note that we sent through to the committee. The last addition that I mentioned is under the heading of language. And I just want to go down to it to point out that we have added it. It starts on page 15, and it is Chairperson of the Council of the University of South Africa and others versus AfriForum NPC. There's an excerpt from that case there, which dealt with UNISA's language policy. Thank you, Chair. Also, just to point out, we have sent through a resource list of all the resources that we used in compiling Annexure A, just so that the committee can click on the hyperlink if they want and go through to all of the resources that we used. Thank you, Chair.
Thank you very much. Mr. Dupree.
Thank you, Mr. Chair. Mr. Chair, what the department has done in the meantime is to start cleaning up the working document. However, you will note now that all the highlights are only in grey, and that is just a caveat for ourselves to ensure that we prepare a proper A list where amendments are to be made to the bill as introduced. Now, Mr. Chair, with regard to the preamble, I would like to highlight Section 16 of the Constitution to you. We will get back to that issue when we get to clause 4 of the bill and the proposal by the department. However, Mr. Chair, just to indicate to the committee and maybe emphasize at this stage that freedom of expression includes freedom of the press and of other media. Now that is Section 16(1)(a) of the Constitution. Freedom to receive or impart information or ideas, that's 16(1)(b). The freedom of artistic creativity, that's 16.1c, and then academic freedom and freedom of scientific research. The two that I would like to highlight to the committee is actually in section 16, a distinction is drawn between freedom of the press and then freedom to receive or impart information. However, Mr. Chair, with your permission, I think we can maybe go through the bill clause by clause. I will highlight section 16 to the committee when we get to clause 4 of the bill. With regard to the definitions clause, once again, everything has been indicated to the committee at the previous meeting. There was a proposal by one of the members that harm should be defined as any deep emotional harm. Sorry, Chair, I see a hand has been raised.
Okay, let me check. Honorable Swart.
Yes, Chair. Yeah, I'm just looking where that insertion is. I thought it was inserted previously under harm, the definition of harm. And I said that was the motivation, was to bring it in line with the Quilani judgment, which would mean the deletion of the word any and the insertion of the word deep. Now, I see the word substantial there, but the word any was not in the Quilani judgment. So I don't know. I would suggest that we take out that word, or just note that. But yeah, I suppose the question is substantial, whether it is substantial and deep mean the same thing. I'd just like to hear Mr. Dupree on that. Maybe we should just stick with the word deep, because that is that was the Quilani judgment's definition of harm. And I'm just trying to understand, this is now, we're dealing with a proposal, so this is an option, or are we, Chair, I need your guidance here, because then I want, if this is the option, then the word substantial must be deep, and I want the word severely undermines. Deep emotional and psychological harm. And I've also got a challenge. I need a discussion around the word social and cultural, what the implications are, because this is a crucial definition that will lay the whole basis for the bill. So we need to just engage on this. We've had discussions on it before, but the proposal, and it's different levels of proposals, because I do appreciate that we are now busy engaging on this issue. So, Chair, maybe we can have a short discussion on this, where I can get guidance from Mr. Dupree. Firstly, on the word substantial. Secondly, on the insertion of what is meant by social, cultural, economic, given the fact that in the Quilani judgment, there's only reference to deep emotional and psychological harm that severely undermines the dignity of the targeted group, which is a much narrower definition, and which is something that we should consider, given the fact that we are not criminalizing hate speech, and it should have a much higher threshold than Quilani, which related to civil action. Thank you, Chair.
Thank you very much. Before we come to you, Honorable Hendricks, Honorable Jelle, firstly, I will find the definition of communication. Honorable Hendricks, just a bit, wait a moment. I will come to you immediately after this. So we are fine with the others. Because there was no hand raised, so should we go to harm, or should we go one by one to ensure that we are fine with the other definitions. Because I think a definition of communications, we must be absolutely fine that it covers what we want before we go to all issues relating to harm and other issues. So I will fine with the communication as it appears. And so maybe let's lower our hands because the hands that are up with respect to definition of harm, I think for the purposes of, I think let's say the hands that must be up must be in relation to communications. Honorable Hendricks on communications.
Thank you, Honorable Chair, for this opportunity. I don't know, Honorable Chair, if this relates to communications or whether it is a point of order or whether I want more information. But there has been reference to a working document and there's been reference that this working document, additional information has been added. And my parliamentary constituency office has received substantial concerns about the fact that there's been so many changes and that they haven't had the opportunity to comment. And they also tell me that before the portfolio committee can deal with these matters, there must be a certificate in terms of the National Assembly Rule 279.4 that it is conforms to legislative drafting practice and consistent with the Constitution. Now that all these substantial changes has been made, there is a case that before this portfolio committee can do what they want to do today, that we must get another certificate because all these changes that have been made, it may be that those responsible for issuing the certificate in terms of National Assembly Rule 279.4 may have a different view and may not find that the bill as it stands today, and some more stuff is going to be added, I believe. You can't add more stuff while we are trying to approve things and we haven't had opportunity to discuss with the constituency. So this is just, I know I'm a latecomer, Honorable Chair. We only have one seat in Parliament. I followed what has been happening through YouTube. I could not attend all the meetings, and my apologies that I couldn't actually attend the meeting because I'm only an ad hoc member. But I'm shocked by all the representations made to me in the last few days that how can we, as a portfolio committee, deal with all this and approve it clause by clause if a certificate in terms of Rule 279.4 may say, no, we are not going to, these changes that the Honourable Deputy Minister is pushing and dying for doesn't have constitutional muster. So I feel, Mr. Chairman, you must guide me now. What do I tell my constituency? We had a mosque on Fridays, and they're going to ask me all these questions. What do I tell them? And just lastly, I would like to thank the ACDP for getting us the exemption. However, there's a problem with the exemption that the person that is being charged must prove that he's not guilty. When it comes to bona fide, I think it is a responsibility of the prosecution authority to do that, because many of our constituencies, I mean, they don't have they don't have the knowledge and the talent, and they are just simple people. They can't come and defend themselves and it's very expensive. But coming back, Honourable Chief, you are happy that the changes doesn't merit a relook for a certificate. So be it. But we certainly going to have to look at this very closely. Thank you very much, and sorry for taking up so much time.
No, thank you very much, Honourable Hendricks, for your comments. But we would not punish you that you've got a lot of work. You are an individual member. who is in many other committees, but what we can say is that we have had public hearings. The public was given an opportunity to comment, and the public was also given an opportunity to come and make presentations. I think we had public hearings over 2 days on this bill, and this bill has been on the pipeline for some time. We have had quite a number of engagements as members of this portfolio committee, and you would agree that the way of processing bills in Parliament is that it has got stages. Once the bill is introduced by Cabinet to Parliament, we invite public for their comments, and you also have to have time limits. And then after that, then you start, and then the department responds to issues raised in the public hearings. They might agree with others and not agree with others. Then after that, then we start having an engagement as members and having a debate, as we have been doing. And to an extent that even members made their own submissions. We received a submission from Honorable Maseko Jele. We received a submission from Honorable Horn. So we are at a stage now where we have to, we have considered all of those, and we are debating amongst ourselves. As we have just started now, Honorable Horn, not Honorable Horn, Honorable Swart has a view that needs to be engaged upon on the issue relating to a definition of harm. So we are quite, let me say that I think we have followed the procedure that we have always followed on all other bills. There will absolutely be no need to reopen public hearings at this point now. I hope that clarifies issues, Honorable Hendricks. Honorable Chair.
Honorable Chair, that does clarify it. I'm not calling for public comment. They had their chance. They can go to the other parliament if they've got comments. What I'm talking about is there's been so much substantial changes after everything you've said. Will the parliamentary unit, the legislative, the parliamentary unit, re-look at whether we are still compliant and that the changes is not consistent with the Constitution? Give us a certificate to say, no, everything is fine. And we know we are working with a document that is constitutionally compliant. It's not the cabinet. Even the cabinet's proposals goes to this committee in Parliament that have to give a certificate. The cabinet doesn't give certificates. But that certificate is an old certificate. We need an updated certificate with the substantial changes that have been made. But I won't take too much of your time. I just want to bring it to your attention.
Thank you very much, Honorable Hendricks. Honorable Maseko Jele.
Thank you, Chairperson. I think I will request that I be assisted here, Chair, because I also would want to make a comment also on harm. It's either this word that I'm going to mention belongs here, or it has to beef up the harm, the definition of harm. But I'm subject to correction, Chair. The issue here, because I see here on communication, it speaks about oral statement, representation or reference, but too much I'm on this oral statement. It doesn't cover me. I think, Chair, if I'm not wrong, the issue of utterance, because this is talking about the statement only. Somebody can say a word or name calling, Chair, and you find that that thing it impacts on this person according to our definition harm. Where is this issue? Can I put the word utterance here? or what? It's my
Okay.
question. I'm not sure. It's my question, Chair.
Okay, thank you very much. So you are on communication. Okay, thank you very much. Honorable Ngola?
I'm still going to, sorry, Chair, I'm still going to come on definition, but I'm here for now.
Yes,
Or you want me? Yes, you want me to cover both?
Is everything on communications?
Okay, Chair. Let me say let's go back to definition where it talks about emotions, Chair. The proposal that harm means emotional.
No,
there are two
sorry, no, sorry, Honorable Chair. You are
Yes,
now
Chair.
on harm. We are now on harm. We are still on communications. And on communications, you have raised the issue of utterance.
Yes.
So saying that raise everything on communication, you're still going to come on others.
Okay. I'm happy, Chair.
On communication, you're raising utterance.
Yes, Chair, I'm happy. Just to
much.
qualify that, Chair, it is because here they only covers oral statement. And
Yes.
when I talk about utterance, it means even a word. Only one word can cause a harm. Thank you, Chair.
Thank you very much. Honorable Ngola?
Thank you very much, Chairperson. Apologies for the background. I'm in transit. I reported in the morning. Chair, one, I equally agree with the utterance that it must. I agree with the utterance as well. The second issue, Chair, I think you have raised the trajectory that we have traveled in trying to deal with the contents of the bill and the substance of the bill and ensuring that it meets the constitutional matter. So I agree that we have long been processing the bill, and there is still work that needs to be done beyond the committee process. So I think we equally need to, not to be unfair to those who are to receive the bill and process it beyond this committee work. So if there are issues with the issue relating to a certificate and all that, I think there is we do have the Parliamentary Legal Services that is designated to advise us when we take an off ramp in terms of the process that we were supposed to have taken. So I wish to agree with you that let's proceed with the bill so that we're able to complete in time and allow other processes to unfold. Thank you very much.
Thank you very much. Honorable Nibot Trocha.
Thank you very much, Chair, and good morning to everyone on the platform. I want to ask Mr. Duprier a question in relation to the word utterance and oral statement. So Honorable Jele has raised the word utterance as meaning one word, as referring to one word. But perhaps does oral statement also refer to one word? So are these words synonyms, or are there is there other terminology that can be used in this case, in this regard? Thank you, Chair.
Thank you very much. Honorable Swart.
No, Chair, I'm covered on this issue. Thank you.
Thank you very much, Honorable Swart. Honorable Engelbrecht.
Thank you, Chair. I just want clarity in terms of the way that we proceed now. So we are now at definitions and the word communication. So are we going to go through each and every single one? And then as and when we are at a particular term, we can then give input should we have any, or are we going to go through the definitions first completely, and then after we've gone through the definitions we can then raise certain issues should we have any such at this point?
Now we are going through the bill clause by clause, including definitions. So we are at a stage where we are going, we have started now with definitions, and we are going to go to the body of the bill, clause by clause. And if members have got issues to raise in relation to that clause, they will raise it.
Okay, so once we get to the definitions that I might have something to add, I will then raise my hand and say what I want to say, that specific clause or definition.
No, that is, I think that will be proper, Honorable Elderberg. Honorable Hendricks, is that an old hand or a new hand? Honorable Hendricks. Honorable Hendricks. Honorable Newwood, is that an old hand or a new hand? Okay, it's an old hand. Thank you very much. Mr. Dupree.
Thank you, Mr. Chair. Mr. Chair, yes, we cannot advise you whether the committee should decide to get that certificate, that 279 certificate or not. But however, I would like to point out to the committee that although it appears that there are many substantive amendments to the bill, and we'll get to that when we get to those clauses, there are actually only 2 substantial amendments being proposed, and that is with regard to the definition of characteristics, and then also with regard to the definition of grounds, especially when it came to the definition of grounds. The introduced version of the bill included all the characteristics except for 2 exceptions. So the proposals that are being made is actually a redrafting, for example, of clause 3 as it was introduced, but it does not really add or detract any additional information. So on a technical level, I would argue that the amendments are not that substantial. It's merely a redrafting, if I may put it that way. With regard to the question of communication, I understand that the word statement might be a bit confusing, Mr. Chair, because if one talks about the word statement, then one thinks that it's something that you say that is very long and does not necessarily include an utterance. However, Mr. Chair, in my personal view, the word statement or oral statement is precisely that what it is. I say something, even if it's only one word, it's a statement that I make. So I would like to argue that the word utterance forms part of the definition of an oral statement. Sorry, Mr. Chair, I see that there are hands raised.
No, focus on your response. I will give opportunity to those hands once you are done.
Thank you, Chair. Mr. Chair, I think I've raised all the issues, well, primarily, of course, overall with regard to the substantial changes concerned, with regard to the bill as a whole, and then also with regard to the concerns that have been raised regarding the words oral statement. Thank you, Chair.
So does utterance exclude oral statement? Which one is more encompassing than the other?
Mr. Chair, I would say oral statement.
Why so?
Because, Mr. Chair, either
Can I
is
on this point.
Hello?
Hi, yeah, no, Chair, can I come in on this point that you're engaging with Mr. Dupree on?
Maybe you can switch off your video. You are not clear. Yes, we are coming into Deputy Minister.
No, I was just looking at the dictionary definitions, and basically utterance is a spoken word, statement, or vocal sound. And whereas a statement is, where am I? A statement is defined dictionary-wise, a definite or clear expression of something in speech or writing. Okay, we're talking about oral statements, so we're not talking about writing. So, look, it would appear from the dictionary definition that utterance is broader, that utterance includes utterance includes statement, or from the dictionary definition that I've looked at, which I've just found on Google. So what I would want to suggest is that, I mean, I think the intention of everybody is clear. We want one word to be covered as communication. I'd want to suggest that you know, we also have to look at, or the department will also have to look at. I've just gone on dictionary stuff, the legal definition of statement, but that we do consider changing statement to utterance, but come back to you at the next meeting on that point.
I think that assists Deputy Minister, Honorable Swart.
Yeah, I just wanted to comment on Mr. Dupree indicating about the amendments to the bill and Mr. Hendricks's point. But I think we need also our parliamentary legal advisors to look into the issue. Whilst Mr. Dupree indicates that there aren't that many substantive changes, if one looks at the issue which is at the heart of the bill about characteristics and grounds, then I do think we need guidance from the parliamentary legal advisor. I'm not sure if they are on the platform, or maybe to consider this, consider the issue that Mr. Hendricks does raise, purely from a compliance perspective. But in my experience, we do amend as we're going along. We amend a lot of bills going along. So, but it would be good just to make sure that our parliamentary legal advisors are also on board. Thank you, Chair. Chair, I just also want to just understand the process now, because we're starting to go through clause by clause, but I also understood we were going to have a debate about each of the grounds. Now, I presume that's going to come at the time we're dealing with the grounds, when we deal with that definition. But I'm just a bit concerned that we now, and I appreciate the process, but I just need clarity. We got a research document now on all the grounds, and I thought we were going to have a debate on those specific grounds. And my concern is that members, for whatever reason, that were very involved in that, such as Mr. Horn and Ms. Breitenbach, aren't on the platform, but they've given apologies, and we appreciate the process must continue. So I'm in your hands, Chair. That's why I didn't object to us going clause by clause. I think we've got to start that process of the technical side of things as well. Thank you, Chair.
Chair, can I just come in on the technical side that Mr. Hendricks raised and Mr. Swart has spoken to?
DM, you think the chair is here? I think it's not here. Let's check.
Oh, okay. Oh, no, sorry, I was, I did not unmute myself. Thank you very much, Honorable Jailer, for alerting me. Can you hear me now?
Yes, Chair, I can hear you.
Oh, okay. Thank you very much. I was saying that we are dealing with the bill clause by clause, and there is nothing that will prevent a member from raising issues once we come to that clause, whether it's characteristics or grounds. We're still going to those clauses. But we should also bear in mind that the document was submitted for members to read, and the document is a reference. It should be used for reference purposes, and members can use the documents to argue their points. But we are going to come to the grounds, and members can as well raise their issues when we reach that particular clause. But it's important that we should process the bill clause so that we know what is it that we are agreeing on and what is it that we are disagreeing on. But we need the bill to be, we need to start dealing with in fact, we need to deal with the bill clause by clause so that by the end of this process, we will be quite clear where we are, that on these issues we agree, on these issues we disagree, as we are now doing with the issue of the definition of communication. We agree on everything except that the issue that needs to be worked on oral statements versus utterances. Members that have spoken now generally are raising an issue which for me is the reason that they are tilting towards utterance other than oral statement. That is where we are now. We have to go through the bill, all the clauses, and whatever material included in this research document is for reference purposes. Honorable Deputy Minister.
No, Chair, thanks. Just on the issue that Mr. Hendricks raised, and I'm surprised that Mr. Swart, I mean, Mr. Hendricks is new in Parliament, whereas Mr. Swart has had a lot of experience. The issue of certification in terms of the rules is that when a bill is introduced by a member of cabinet or deputy minister, it must be certified by the chief state law advisor or a state law advisor as being consistent with the constitution and properly drafted. And if it's not so certified, the report must be submitted. I think what Mr. Hendricks is referring to is a bill introduced by the committee or an assembly member must be certified by the chief parliamentary law advisor or a parliamentary law advisor that it's consistent with the constitution. That is the bill as introduced. So it's not, maybe at the end or presumably at the end, before the committee votes on the bill or before it goes to the House, the parliamentary law advisors will look at it. I'm not sure if that's in a specific rule, but they should do that it is still correctly drafted and consistent with the constitution. But I think the rule that Mr. Hendricks is referring to is on introduction. Then on the issue of I don't know if the issue was that how substantial are the amendments. The issue is basically that the committee considers, as it processes the bill and considers the public inputs, it amends the bill. The question is basically, and I don't have the specific rule in front of me, is if there's a substantial change to the bill. I think the previous chair, Johnny de Lange, used the term, if there's a change to the pith and substance of the bill, then you'd have to go back to the House to ask for permission to re-advertise. But I would argue that none of these changes are affecting the pith and substance on the bill. They are basically important amendments, but I don't think they warrant further putting it out for further public comment, which would have to be the permission of the Assembly. But anyway, let's not argue this point. Let the parliamentary law advisors advise, but I'm not aware and have had no experience in my long time together with Mr. Swart in Parliament of parliamentary law advisors having to come in as we consider each amendment. Thanks, Chair.
Thank you very much, Deputy Minister. I think that assists.
Chair.
Let me check. Honorable Swart.
No, Chair, it was not my intention that parliamentary legal advisors comment on each section. It was purely, as has been the course, we had it with the cannabis bill, that there will be a time when they will be looking at the process. And we have dealt with other bills, we have asked their advice as we go along for a different view to what the department might hold. So it's not that I'm arguing. I do maybe not agree with the Deputy Minister. I think there are some amendments that are substantial. And that is why we are receiving letters that people want reopening for further public submissions, public hearings. But I appreciate the process is ongoing and we have had public hearings. So we're still engaging with those issues. But the point I want to conclude with is that it is helpful to have parliamentary legal advisors to give us an alternate view, given the fact that we're not all lawyers on the committee, and that I don't want this to be a debate between myself and the Deputy Minister and the department. I think we legislature, we are the ones that finalize this. And yes, whilst the Deputy Minister and the department might hold a certain view, oftentimes in my experience, the committee might hold a different view. We've had it in the RABS bill in transport where a committee rejected what the executive said. So let's not be, I might be persuaded in certain regards, but I think we as a committee can take a different view to what the executive also takes. So I just wanted that focus as well. Thank you, Chair.
Thank you very much. Who is Susan Isaac?
Good afternoon, Chairperson. I am Suan Isaac from the Parliamentary Legal Services.
Oh, okay. Welcome.
Thank you, Chair. With your permission, can I just make a comment on the issue of the certificate?
Yes. Yes.
Yes, Chair. Chair, we do not issue a certificate at this stage. The certificate is issued at the stage of introduction. Members are currently deliberating on the bill, and as the proposals are, more formalized, we will comment and advise members if there is any constitutional or other legal issues that they need to be alerted of. So I am present, and if there's any matter that needs to be raised, I will. As the deliberations progress and there's more finalization on the proposed amendments, you will raise issues if there are any for the members to. Thank you.
Thank you very much. I think that takes us forward, members. There will be a time when they will, even before we debate the bill, where they will also look at the bill. But even if we move away from what is constitutional, they're always with us. They will indicate. We have also, even with cannabis bill, we have given our parliamentary legal advisors and the research unit some time to look at the new clauses that we have inserted. So I think it's an issue of procedure, which I think Ms. Isaacs has explained. I think let's come back to the bill. And move forward. Honorable Jale.
Yes, Chair. Thank you very much. I just want to make a comment in terms of this thing. I think, Chair, we have covered a lot when it comes to this bill. Indeed, I agree with you, and we are somewhere now about to finish it, though we are now cleaning it and all that. My take on this, Chair, I think I want to say this early before we finish this bill, so that we continue thinking about it and then come back to it, Chairperson, when we finalize the bill. I think we need, Chair, another bill that is going to address the issue of equality. Because some of the reason when I was analyzing this thing, and also I had a discussion also with the DM about this so that I can get more clarity. I realized that some of the issues on my part, I don't know about other honorables. It's like we wanted to put them here in order to cover other issues in terms of equality and discrimination. There's a lot that we have to do when it comes to issue of equality, Chair, that impacts on this issue, on this bill. So I was going to propose, if it's not out of order, Chair, I'm not out of order, going forward, when we finalize this, we must think of introducing a bill that is going to talk about these issues that we wanted to keep on, those we kept on bringing them here and not belonging here, Chair. That's my view, but it's just a 2-cent input that I think that in future, as we proceed, Chair, we must look into it, think about it, and come back to it. Thank you, Chair.
Thank you very much. I think the consensus is that we need to proceed, and we come back to the issue of communications. The department is going to go and look at the issue of oral statement versus utterance. Quite a number of members are preferring the use of utterance, but we must look at also the legal definition of oral statements. And I think
Chair, you've frozen. Maybe you should switch off your camera.
the department is still going to data.
Chair, sorry, you froze. Maybe you should switch off your camera. I think the bandwidth problem is your side.
Oh, okay. No, I think I must move to the next and must use another device.
Chair, before you froze, you were saying something. Can you maybe repeat, please? Honorable Neo Dukun is asking.
Thank you very much. I was saying that let's come back to the definition of communications. The department will need to go and do a bit of work on oral statements versus utterance. Quite a number of members who spoke are in favor of the usage of the word utterance. But we are saying that the department must go and look at, must go and do further work. If there is a definition of oral statement, they must look at that. But for now, we are happy with communication subject to further work to be done. I was saying that let's go to the next definition. And I was arguing that court I don't think that it means what it means. It's defined in terms of the Act. I'm not sure whether members would want to speak on the definition of court and criminal procedure, which I think are straightforward. If there are no hands, maybe we can go to data. There are no hands on data message. We are fine with data message. Director of Public Prosecutions. It is what it is. We all know it. Electronic communications. We are happy with that. Electronic communication systems. Honorable Engelbach.
Well, thank you, Mr. Chair. In terms of electronic communication systems, but that also will include the data and all means of social media and the whole, as everything together. If we look at what happened in Germany, which has, I mean, and they have very extensive hate crime and hate speech laws, and they had a need to, in 2018, introduce a social media law, because as it is with all legislation, the devil is in the definition, and it is so broad and so difficult to police these kinds of messages that appear all over on different kinds of social media. Just as a precaution, I think there might be a difficulty in terms of the electronic media, social media segment, where you have to police, find out where it comes from, curtail the spreading of any such messages. Maybe it would be worthwhile just having a look at the German experience, because as it is right now, they have endless problems with that specific piece of legislation that I believe they tried to prevent wrongdoing, but in doing that opened a whole other can of worms, which they seem to be incapable of addressing all the other problems that arose from that, in terms of this very specific thing that I think is probably something that would be headed our way at some point.
Thank you very much, Honorable Engelbrecht. Any comments on what he has raised?
Chair.
I have Honorable Engelbrecht, Honorable Maseko Jele, and then Honorable Deputy Minister.
Honorable
sorry, it was
Neodruchen
all
has a hands up.
Sorry?
Honorable Neodruchen has her hand up, Chair.
Yes, you are the first one.
Okay. Thank you, Chair. I noticed the word social media is not in the bill, so I want to know which word, data communication or electronic communication system, what will cover social media, keeping in mind that social media changes all the time. It comes and goes, new platforms, the future, there might be new systems that come up. So, what is a word that covers all kind of social media, whether it's WhatsApp, Twitter, Facebook, mix it, that was an old system, those kind of things. What is the word, the current word there? Does it cover all kinds of social media?
Thank you very much, Honorable Jele.
Thank you, Chair. I thought, Chair, I think, I'm not sure I'm going to listen to the response. I think I was on that issue of social media. I was about to support it, but I will listen to the responses. Thank you, Chair.
Thank you very much. Honorable Deputy Minister.
Chair, thanks. Look, I just regarding responding to Mr. Engelbrecht's input. I mean, maybe the officials can look at the German issues, and he can refer which sections to them. But remember, this is a bill criminalizing. And these provisions are effectively about hate speech that we're dealing with now, not hate crime. And it's criminalizing that. So the aim of the bill is not to prevent the spread. That's left up to other legislation, for example, the Cybercrime Act, to restrict the spread of information. And then just while I'm on the floor, it should be more, Mr. Dupree probably, but let me just assist. The communication is an electronic communication, includes an electronic communication. It's unfortunately one of these definitions you've got to read right the way through. An electronic communication is then defined as a communication by means of a data message. And a data message is data generated, sent, received, or stored by electronic means. So that's basically Now, I would argue very strongly, there's no definition of social media. As Honorable Nivo Drushin has said, it changes from Mixit when we were dealing with the Popia bill. Mixit was big, and now Mixit is gone. A while ago, we just had WhatsApp. Now we've got Signal, etc., etc. So I would argue that the issue of data and electronic communication, data and data message covers any communication
Sorry, TM.
Sorry,
TM.
Yeah.
I was locked out. You were saying on social media, and then I think I was cut out after that.
Okay. What I was saying is there's no definition of social media, and it keeps changing the whole time. When we were dealing with the Poppy Act, the Poppy bill, Mixit was big. Now I don't think Mixit exists anymore. We had only WhatsApp. Now we've got Signal and a range of other ones. I would argue that all of that is covered by electronic communication, the definition of electronic communication, the definition of data, the definition of data message. You can't have social media without a data message or data which is covered in it. So the officials can maybe, Mr. De Priya can maybe, or somebody else can, Ms. Botha can, or Ms. Pillay can maybe come in there, but I feel that we've covered an electronic communication would include any communication on social media, whatever that social media is. Thanks, Chair.
Thank you very much. Honorable Nivo Drushin, is that a new hand or an old hand? Honorable Masego.
An old hand, sorry, Chairperson.
Okay, Honorable Chel, is that a new hand or an old hand?
Old hand, Chair.
Honorable Hendricks, is your hand up? Okay, let's keep our hands down because they tend to confuse me, and the only hand that will allow it to be up continuously is the hand of Honorable Hendricks. Mr. Dupree or Ms. Botha or the DDJ, Ms. Pillay?
Mr. Chair, the Deputy Minister actually took the words from my mouth. I would have wanted to argue, and as the Deputy Minister said, he feels strongly about it, and the department also feels strongly about it, is that social media will be included, because I think the common denominator in electronic communication is the use of data and data messages. So that would be the bottom line for me, Mr. Chair. However, Chair, I have made a note, and we can maybe just revisit it amongst the team members just to satisfy ourselves that social media is included. But I'm quite satisfied that social media is included. Thank you, Chair.
Okay, and then you will also look at that German legislation.
We will do that, Mr. Chair.
Thank you very much. Electronic communication systems, I think we have done that. Harm.
Mr. Chair, yes, thank you. The first.
Sorry, before you move, Ms. Pillay's hand is up.
My sincere apologies, Chair, but I just wanted to reflect on the definitions that we used when we did the Domestic Violence Amendment Act before this committee. And there was a definition of electronic communications there. And if I may read that out to you quickly, Chairperson, and I don't know whether it's going to be of assistance here, it says, means electronic representations of information in any form and includes, without limitation, voice, sound, data, text, video, animation, visual images, moving images and pictures, or a combination or part thereof that is disclosed by means of an electronic communication service. And I recall at that time, Mr. Robertson, when he was also working on this bill, actually drew from the Cyber Crimes Act, etc. So we wanted to seek as much alignment as possible. So I'm just raising that to see if that will assist the committee in this regard, so that we don't reinvent the wheel in respect of electronic communication. Thank you, Chairperson, for the opportunity.
Thank you very much. I think for me that does assist, because there must be consistency in definitions throughout. You can't have different definition on the same issues by different legislation. I think let's try and achieve some form of consistent definitions. Ms. Botha?
Thank you, Chair. Just to add to what Mr. Dupree and my DDG, Ms. Kalle Pillay has just said, I want to just highlight that the definitions which we've pulled, which we have here, so for electronic communication system, data and data message, they're all pulled from the Electronic Communications Act. It's Act 36 of 2005, so that there's consistency in sort of the act, which is the genesis of electronic communications, and even that act doesn't define social media. Just to say that. Thanks, Chair.
Thank you very much. Let's go to harm. I think let's take this opportunity to first give to Honorable Swart, because I think we interrupted him when he was already on the floor on this issue.
Yes, thank you, Chair. This definition is at the heart of this legislation. And that is why it is very keen, very important that when we evaluate it, that it cannot be cast too wide. Otherwise, there's no reason then to list all the different grounds. At the moment, as it is, in my view, it's still too wide. And that's why I suggested we follow the definition that is set out in the Constitutional Court's decision in the Kwelani matter. But one should even narrow it further than that, because that is a civil remedy. Here we're dealing with a criminal remedy, which needs a much higher threshold and a much narrower definition to understand what the crime we are creating. Because if it's too broad and too wide, then you can face a lot of constitutional challenges, a lot of defenses that one can face. So that is why I initially suggested the insertion of the word deep. And if you follow the definition in the Kwelani judgment, there is also no reference to the word any. So my suggestion, and I see it's now a proposal, so I need to understand this process, because when the issue of utterance, there was an immediate insertion there. So I need to understand how we're going to deal with this, because previously it was decided, or let's leave it as a proposal. But I want the department to just respond on a number of issues here. Firstly, the issue of the removal of any. Secondly, the substitution of the word deep to substantial. I think that could be a good idea. And then the motivation for the insertion of the words social, cultural, and economic, which are not referred to in the Kwelani judgment on harm. And that is very, very broad then. And that's a deep concern from our side. We need to narrow down this definition. And I want to quote, I think it's important that we need to understand what we're dealing with here. We are not dealing with name calling. We are not dealing with pure saying things that are offensive. If you look at the Kwelani judgment of paragraph 103, hate speech is speech that goes way beyond mere offensive expressions and can be understood as extreme detestation, extreme vilification, which risks provoking discriminatory activities against that group. The expressions that are merely hurtful, especially when understood in everyday parlance, are insufficient to constitute hate speech. Offensive speech is protected by freedom of expression. So I think when we are dealing with this, we need to understand this as the beginning point, that this is hate speech that is beyond merely offensive speech. And so I would need to debate this issue and understand why these words are inserted, because to me, social, cultural, economic are so broad that it can lead to constitutional challenges. It can lead to, particularly given that the issue of hate speech in a criminal context was traversed in great detail by the Constitutional Court in the Kwelani judgment. And these are issues that then can raise the advice from the parliamentary legal advisors as to whether what we are now doing is constitutional or not. Doesn't have to be certified, but as we are moving along and we try and I thought the uitgangspunt, the premise was that we are going to bring the hate speech provisions, the harm provisions in line with the Kwelani judgment. And maybe we have done that, maybe we haven't, but I would like some to debate this issue. Thank you, Chair.
Thank you very much. Before I move to Honorable Engelberg, I think the word any, we had already agreed. I think we agreed with its removal a long time ago. I think that was the first, that is why you remember you suggested the word deep, and there was an agreement. And I think the issue now, it would be whether we say deep emotional or substantial emotional or any other word that, but we had long agreed on the removal of the word any. Ms. Honorable Engelberg.
Sorry, Chair, sorry to interrupt. Could I then, I'll just ask, why is it still just a proposal? Is that, why is the text not already changed? Or are we, for me, I read this as a mere proposal now, whilst you correctly are saying it was already agreed. So the text should be changed already.
Okay. Honorable Engelberg, I think the department will answer for itself. Honorable Engelberg.
Thank you, Mr. Chair. I largely agree with Honorable Swart, and I will not repeat what he said. My specific difficulty with this clause is what constitutes social and cultural crime. Because look, if this is a criminal offense and the prosecutor have to prove beyond reasonable doubt that an individual or a group of people suffered substantial cultural or social harm, is it possible? I mean, what is being defined here as culture? I mean, what social do you refer to here? To prove psychological or physical or economic detriment, I think is relatively easy, but social and cultural, you know, it's a matter of perspective, and I mean, so it's not clear, and to only merely put these two terms there is so broad as the Lord's grace, in that you can interpret almost anything in there, and I think we need to narrow it down, because the poor prosecutor that needs to take on a case and prove beyond a reasonable doubt that this is indeed the case is going to have a very substantial problem, to my mind. Thank you.
Thank you very much, Honorable Engelbrecht. Honorable Deputy Minister.
Chair,
Thanks.
my hand is up.
Oh, Deputy Minister, would you mind to speak after Honorable?
That's fine, Chair.
Yes.
Chairperson, thank you very much. Yes, thank you. Thank you, Chair. Can you hear me?
Yes, we can hear you.
Yes, Chair. I think I still support the issue of the social culture and economic chair to be included. I think we'll wait for the department to respond to that, and then we will also continue looking into that. But on harm definition, Chair, last time, Honorable Swart is correct. We were talking about that. He proposed the name. I mean to say the word deep. And today, I think while we agreed with him at some point, but also taking into consideration that the debate is still going on. On my side, I was going to say, let's replace it with strong, because I went to the dictionary, Chair, and looked. I don't know if maybe, like you say, some other terms, maybe legally, we can have a problem. But on this one, when I was checking from the dictionary, the word deep and strong come out to be the right or the correct word that I feel that it must be used, because the definition is almost the same, but they differ only two things. The strong, Chair, refers to fear. In fact, they give us those Chair, they give us the same words which are synonym to that, but they differ. Like, for example, on this one, on strong, they give us fear. It means this statement or whatever can also bring fear. The reason why I'm saying this, it qualifies that issue of advocacy or not on when you go to section 16. Section 6, where it says advocacy of hatred and all that. That which, for example, when you go on, they say that constitutes incitement to cause harm. So fear, to me, I felt that it is the right word that can be strong, can also give a strong motivation for me to say, let's replace with strong, because on the deep, the word that they used there, it was the word like prohibition, something like prohibition, or we prohibited to do something, but that's just that I don't have my notes with me here because of this gadgets of network, this network story. But I think strong emotions, for me, they come out clear. I would propose that, replace deep with strong. And on the issue of, Chair, remember earlier I said that issue of, I think also the issue of verbal, it must be included also. It's either it's fine because we've got utterances down there, but here, Chair, we are talking about emotions. Which emotions? We're talking psychologically, that's in my mind. We are talking physically, like if you can hurt somebody, but also we can say something to qualify that utterances that we were talking about. That can be detrimental to an individual or a grouping. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Chair, yeah, I mean, again, apologies to the departmental team if I'm a bit, look, just firstly to Mr. Swart, I mean, why are these changes not in? I'm not sure. I think I wasn't there when you were discussing the word any. I'll leave the department to respond to why that wasn't removed. But basically, as I understand it, no decisions are being taken. That's why they're alternative. The proposals, where there are proposals, they are what we are proposing, as opposed to the other amendments, because you've got what's there originally as harm with the gray stuff, and then you've got another one with proposal. But my understanding is no decisions have been taken yet. Now, on the issue of harm, just to say that there's no definitive definition of harm in the Kwelane judgment. I agree with Mr. Swart that it is also about the civil component. What the judge, I think it was Majid, says is a number of issues. He says, on a plain reading, harmful can be understood as deep emotional and psychological harm that severely undermines the dignity of the targeted group. I think that's where Mr. Swart's deep came from. Mr. Swart, I think I heard him express some support for substantial. Ms. Honorable Maseko Jele has spoken about deep. My concern with, well, sorry, of strong rather. My concern with strong is substantial is legally clear what it is. I'm not sure if strong is legally clear. So it might be one thing what the dictionary defines, and even Majid used deep, which I would have thought substantial is better, but it's a question of is it legally clear? On Mr. Engelbrecht's point about the poor prosecutor and what does social and cultural mean, remember each of these are all in the alternative. So you can prosecute somebody for causing emotional harm, psychological, etc. I think the others were put in to broaden the net, as it were, because also in Kwelane, in that same paragraph 154, the judge goes on to talk about the Kierstra judgment in Canada, where they spoke about two types of unconnected harms. Then he also referred to the Concord case of the Human Rights Commission versus Kumalo, which came after Kwelane.
Honorable Deputy Minister.
Yeah. Can you hear me? Chair, from my side, you've frozen. I don't know if it's me or if it's you.
I think it's Chair DM, because I can hear you.
Okay. Yeah, I think it's Chair, and I do think if he can hear me, which I don't think he can, Chair should, I think Chair's gone now. Oh no, Chair, you there? You're muted.
Sorry, Chair. Sorry, Deputy, I was kicked out when you were talking about the Canadian case. Yeah. Yes.
Okay. No, he was referring to other definitions of harm. So he used deep harm, which is a dictionary reading, but he wasn't saying that has to be followed. He then referred to a Canadian judgment, and then he referred to the Human Rights Commission versus Kumalo judgment, which is a constitutional court one, where they spoke about three types of harm. But the second one, secondly, the type of harm experienced by the targeted group, which includes demoralization and physiological hurt, and the harm caused from responding in kind, therefore creating a spiral of invective back and forth. And then the third one he quotes from Kwelane is harm to the social cohesion in South African society. So I do think issues of social harm, which may be more difficult to define, cultural harm, which was a proposal during the public submissions, which I think are the two that are being questioned, should be looked at. Obviously, when it comes to prosecuting, the prosecutors don't have to look at social and cultural harm to get they can concentrate on emotional and psychological. But just to raise those points. And then there's the issue of undermines the human dignity of the targeted group. But in short, Chair, then I think the department must explain about any, to me it doesn't, it's neither here nor there whether it's there or not. It would appear that there is an agreement that there should be an adjective in front of the types of harm, whether that adjective is deep, substantial, or strong. is something to look at, but I would have preferred substantial because it's more legally clear. I've given the reasons for why social and cultural are there. And then on the proposal, well, because harm is the word harm is changed to detriment because otherwise it becomes a bit circular. And it's then objectively undermining the human dignity of the targeted group or individual. So I think that's my understanding of the definition. But I would agree with Mr. Swart, this is the nub of the bill. But maybe just one other point to members.
Sorry,
you also need to look at. Can you hear me?
Yes, you would agree with Honorable Swart on what?
That this definition is at the nub, that is very central to the hate speech provisions of the bill. So it is important to consider it carefully. But I think the issue is that we know, one other problem where I disagree with Mr. Swart is he said no name calling isn't necessarily harmful. And I would say, yes, it is. If you use the K word, I think that is very causing substantial, deep, strong, emotional, psychological, social, and cultural harm. So a word, and that's why we've got to look at this issue of utterance. But the main thing I wanted to say to members is I think we've got a good idea what we're trying to legislate against. And we need to check, would all these things we know about fall into this definition? Would what Penny Sparrow said fall into the definition of harm? I personally think it would. Would the definition of whatever the no black people in sight on the beach comment, would this more recent one about black people with relation to pit bulls, we need to consider the things we know are hate speech and look at, does that definition fall into it? Thanks, Chair.
No, thank you, Deputy Minister.
Sorry, not does the definition fall into it, but does those examples of what we think are hate speech fall into the definition?
Yes.
Rephrasing it.
Thank you very much. Ms. Silkstone.
Just to add that I had a quick look at synonyms for deep, and the one is profound, and then I was looking at definitions of harm, and then the other word that I found was significant. So those possibly can, I mean, they could all be used. The drafters could have a look at whether those suggestions are helpful as well.
Okay. Thank you very much. But I think generally I think members would agree that whether you go to legal textbooks or case law, or generally there is an understanding, a much clearer understanding of the word substantial in law. Members, I think, should really think about it. Generally, legally, they would use the word substantial more in preference to any other word. I think we should maybe in our next discussion be thinking really about the use of the word substantial. Generally, the question that will always be asked is, what was the intention of the legislature? So which means the legislature must have a clearer understanding of what it wants to achieve. I'm not sure, Deputy Minister, that we can say that we really understand deeper social and cultural or economic detriment for now. Because even the courts, they would assume that the law that we are passing is the law that the first thing is to say, what is the intention of the legislature? then they will move to other instrument of legislative interpretation. But it's clear that we really know, and we have in detail deeper understanding of each and every word. And I am not sure now in a criminal prosecution, social, cultural, and economic. I'm not against them. But I think that maybe we might need to understand them much more better in relation to what we want to achieve.
Yes, Chair. Swart.
Honorable Swart.
No, Chair, I hear, and I am grateful to the DM for the explanation. May I just say to the department, there's no nothing about any, the word any. I appreciate now that we are busy debating these issues. We might have at some stage discussed the word any, but I do remember only speaking about the word deep. So I want to just be fair about that. I think the word substantial is probably better than deep. I still have a problem with social, cultural, economic, as you, Chair, have pointed out. And I think that the Deputy Minister is correct that a prosecutor would focus on emotional, psychological, and physical, and not try to prosecute on the issues of social and cultural and economic. But that, from my perspective, would then substantiate the argument that they should be removed. We don't need them because it just adds to the uncertainty of the criminal provision. And that, as we know, as a legal principle, that any criminalizing in any way, but here in particular with hate speech, which in itself is a very controversial issue. We've got to be very specific in the crime that is being created, and very, the wording cannot be open for vague interpretations, because that would result in any prosecutions being suffering and being very difficult. So, Chair, I think this is an ongoing issues. I know I just wanted to bring that in about the department because I appreciate the work that they do. But I would like also to add, because I see by the insertion of the word substantial, it's been removed from the second part of the definition, which is another additional substantial that should be there as well, because you've got a substantial referring to substantial harm or detriment, and then the word severely should also be there, or substantively as well, as a second part, substantially, because that is what was referred to in the previous definitions in the bill, the word severely, and I probably prefer the word substantially, but it's severely undermines as a second part, as a second adjective there as well. So I think, Chair, these, I'd like to hear what the department says as well, but I think this is the nub of the bill, and I think we're going to have to come back. I'd like to read the Kwalani judgment again, those additional parts that the Deputy Minister referred to, because I think it does add to a broader context as well. Thank you, Chair.
Thank you very much. I would appeal that before we talk about rejecting, maybe next time the department must come with motivation for social, cultural, or economic before we take a decision whether we reject or we agree. I'm just saying that for me, for now, they are not substantially motivated. They might need to be motivated so that we understand as to why they are here in relation to what we want to objectively achieve. Honorable Jale.
Thank you, Chairperson. You have covered me. I thought that maybe I was going to say it was going to be out of line, but I thought that the department can assist us on this because as the Deputy Minister indicated earlier, let's leave it to the department. I agree with you, but I was also thinking that because there was a proposal earlier by Honorable Swart that he wanted, he wished, if for Chairperson, he wished that maybe we can get legal advice and all those things. I think we will also see this when when if that happens. But I think the department are the people who can assist us in terms of the background, why this is included, which I support, Chair. I still repeat, I support that it has to be there, but I agree with you. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Chair, no, I just wanted to raise some issues on social, cultural, and economic harm.
Yes.
Economic harm is easy to measure. That's an objective fact that it causes harm. And could have a situation where somebody says something terrible about Tsonga doctors. That they are, bad things about them, and that basically they're not good as doctors. I'm being polite. You can understand what people could say. And they say these things, and the result is that then people don't want to go to a Tsonga doctor. That's economic harm. So I think that would be an example of that. Social would be this recent any racist thing about any race group, does that not also cause social harm? Did Penny Sparrow just cause emotional harm, psychological harm, or was it also not social? Remember also in Kwelane, the judgment, not Kwelane, in Kumalo, the issue of social cohesion, the harm of breaking up social cohesion. So I'd argue that even this most recent matter with, is it Ms. Bornman, that's causing social harm to our country. Cultural was something that wasn't in the introduced bill. It was put in, I think, as a result of a submission. I think it was from Kasatu. But again, if a group is insulted, if you insult people of Khoisan San ancestry, if you insult them, is that not causing cultural harm? If you say terrible things about Xhosa people, is that not causing cultural harm? Their customs, the way they behave, etc. Is that not causing cultural harm? So I just wanted to put that as a motivation for those categories. Obviously, the issue is going to be, remember that one of the requirements is that a DPP, a Provincial Director of Public Prosecutions, decides to prosecute, although they can delegate that. So it's not going to be any prosecutor on the ground. And if they then prosecute somebody for, it would seem that it would be, primarily emotional, psychological, physical, but they may also want to try social or cultural or economic. So I'm just saying, I don't see this, it's not a requirement that all of them have to be established. It's one of them. Thanks, Chair.
Thank you very much, DM. Ms. Potter.
Thank you, Chair. I just wanted to add on to what the DM has just said. Insofar as it relates to social, cultural, and economic harm, I just want to point out in our research note 2, and primarily in our research note 1, we covered categories of victims and victim selection methods in academic text regarding hate crimes and hate speech. And there are various methods of victim selection, and that can include a group identity, immutability, so characteristics which cannot or are incapable of changing, a history of discrimination or oppression, and vulnerability and difference. So we can see just from the academic text that harm can stretch to more than that suffered by an individual. It can and is meant to cover victims who belong to a group, belong to a culture, and who can then suffer things like social harm, cultural harm, and economic harm. Thank you, Chair.
No, thank you very much, Ms. Potter. Can I suggest the following members for the sake of progress? Before Honorable Nivot.
Thank you, Chairperson. Thanks. The Deputy Minister, I was just waiting for the department to respond to those three things on the social, cultural, and economic harm, but the Deputy Minister did mention with regards to something as an example of the Tsonga doctors in terms of economy, but I would also like to give an example of economic harm if the Council of Social Workers decide that I can't work as a social worker because I am deaf. You know, we might have a case where an employer won't select a person with albinism because he has albinism. And that affects those of us in those groups economically. So it is economic harm. So I just wanted to highlight another example. And I agree that those three terms must stay because it is done, it is being done. So yeah, thanks, Chair.
No, thank you very much. I think it has been a good discussion. Can I suggest the following? Can I suggest that as we have option 1 and option 2, option 1 would be a definition of harm that would include all of what is here, social, cultural, and economic harm. And then option 2 would be the one that would have substantial and then exclude social, cultural, or economic harm. So that, and then also we can have option 3 that would include social, physical, cultural, economical, but start with the word strong and not substantial. And then option 4 would, I think we'll start confusing it. Let's stop at option 3. That you work around those definitions, so that I think by the time we come back, people would already have we debate the options so that we can move forward. Honorable Swart.
Yes, Chair. I was just trying to get a bit of clarity. I like your different options, but it could be they're just working with these different issues. But what I would like is for a consideration for the department to also look at a possible definition. If the committee, and I appreciate we're not taking any decisions now, but a definition of social and a definition of cultural and a definition economic, we pretty much know, but that might help guiding a court. Should the committee decide to insert those words, which I don't necessarily support, but should that be the case, then it could be wise to have a definition of those terms as well. Thank you, Chair.
Thank you very much.
Chair.
Honorable Deputy Minister.
No, I just wanted to say, look, I actually like the word substantial and all these categories. And in terms of your three options, the one that I prefer is not there. I see what you're trying to do, but can we have it as substantial / alternatively, what did people want, deep or strong, so that the committee can look at which of those 3 words it wants, if any?
Yes, I think the people who are supporting deep, led by Honorable Swart, are comfortable with the word substantial.
Yes, agreed, Chair.
Yes, and the person who has not backed down is Honorable Jelle with the word strong. So I think we can leave out deep and have just substantial and strong.
Chair, I think it shouldn't be me. If deep falls, if strong falls and then majority feels they want substantial, and that is the legal weight. All of us we know. No, I'm withdrawing myself too. Thank you, Chair.
Thank you very much. So we are left with substantial. Are you covered, Deputy Minister?
I'm covered, thanks. Yeah, I just didn't like there being no option for substantial and being restricted to deep. Thanks, Chair.
Thank you very much. Thank you very much. Let's go to hate crime. Honorable Swart, is that an old hand or a new hand?
Old hand, thank you, I'm covered.
Thank you very much. Hate crime, any issue?
Sorry, Chair, were we not going to get the department to comment on social, cultural, economic, or has the DM covered that? Oh, Ms. Botha did add to that as well, so maybe that was the department's input.
Yes.
Yes. Okay, I don't know if, thank you, Chair, thanks.
Are you substantially excluding Ms. Botha?
Not at all, Chair. I'm not making a strong, argument for that either. A strong or a deep argument.
I think he's making a deep argument, Chair.
No, thank you very much.
Sorry, Chair, can I just get an idea? I've got connection problems. What are we in a break for lunch, or how do you see the afternoon developing, Chair?
Yes, no, it's an important question. Members, can we break for lunch? What time should we come back?
Chair, I understood we were going to finish by 2 today's sitting, so I have got other arrangements, but what was, so that is the challenge that I've got for the rest of this afternoon. I thought we were going to actually conclude by lunchtime.
Honorable Nivot Drohan.
Yes, Chair. If we do break for lunch now, I just wanted to know how long we will be continuing for the rest of the afternoon. Thanks.
It's important that we must try and push as much as we can. We can't finish at 2 and break for lunch. Because I think it's important that we must try and push as much as we can, or else I would have a suggestion. Because we don't want to exclude people who feel strongly about the bill. I'm not sure about, but maybe let me put my suggestion. Members, we have the 30th scheduled for planning, strategic, in fact, planning meeting. I do understand that, especially on the side of administration and the researchers, this has been a roller coaster time, that we give them enough time to work on the document that often guides us, especially that we'll be planning for a year that is just preceding elections. We must be able to take stock of all the years that since 2019 and how we are going to finish the term properly. So there's going to be a lot of work that is needed. That on Wednesday, we don't we proceed with hate crime, hate speech. We don't do strategic planning. How is that?
I would agree with that, to give the researchers more time. And I think that's a good suggestion, because then we could probably adjourn now. It's already 1:20.
No, we can't adjourn now. We can't do. I think let's try and push. We can't adjourn now.
What time would you want to continue with until maybe a 15-minute break for lunch and then or continue till 2?
If we have to adjourn at 2, then we have to push until 2. What is the view of other members?
Chair.
Yes, Chair, Honorable Neo Druchen, I think we can push until 2. Yes, Chair.
Honorable Chair, thank you very much, Honorable Neo Druchen.
I was going to say that, Chair, and then if any one of us wants to take something whilst the debate is going on, we can have a working lunch.
Thank you very much, Honorable Deputy Minister.
Chair, no, I'm happy to carry on till 2 or longer, but I appreciate if Mr. Swart's not available from 2. We don't want to have to go back over some of these issues if he's not there to make an input.
Okay, and then for the 30th?
30th is fine by me. I assume the department will make it fine for themselves too.
Okay, then we will meet till.
Chair, should we not have a short, just a 10-minute now? Then it's or just a short break now, 10 minutes.
Then we'll break it, and then we'll break, and then we will finish at 2:10.
Well, if we must. I'm not sure why the 10 minutes is a big difference now. I do appreciate that, but it's a Friday afternoon. I thought we were going to end earlier, but let's have a break then. And if you want to, if we end at 2:10, then it's fine.
Okay, let's score past. Let's meet at 25 past.
Okay.
Thank you, Chair.
It will be shared with you shortly. We have received an opinion from legal services concerning the cannabis bill. I mean, I'm just summarizing, but the opinion is going to be shared with us. And I have not read it in much detail, but what the opinion says in summary is that the commercialization aspect, when we went to the house, it was on the basis of palliative, religious, but it was not included. Their view is that we would need to go back to the house to get an permission, and we have to advertise and have public comments. So so there would not be, in fact, that thing for us to move to B list and A list would not be possible for Tuesday. One is that we do not proceed with the cannabis bill on Tuesday. That is the first thing that I think I must bring to attention, which will give us Tuesday and Wednesday, in fact, Tuesday open and Wednesday open, based on the decision we have taken on the what is this thing on the planning meeting. So that is a situation that there is a serious procedural issue that has been raised by legal services on how we move forward to finalize the bill, that is the cannabis bill. So it would be, which means there is no way that we'll be in a position to finalize and to move to A list this year. And there's still going to be a process of public engagement. Honorable Swart.
Yes, Chair, thank you for that information. And I'm really pleased that we have got that legal opinion, given the concerns by Dr. Lutz, who indicated she is under a lot of pressure. So we really appreciate that in the meantime. But would we then not be able to, on Tuesday, have our planning meeting? I'm not sure if our committee researchers would be able to be ready for that. I was also just thinking of other options which we can maybe discuss outside of or discuss at a more opportune time, given the fact that that empowering clause relating to the hemp regulations is almost a duplicate of what is in the Plant Improvement Act, whether, and this we would have to debate in the committee, maybe we can have an initial debate about that on Tuesday as well, whether it's still necessary to include that, because is that not a way of possibly bringing it to finality? But there are arguments both for and against the insertion of that enabling clause, given that the Plant Improvement Act and the regulations there are limited. And that was the idea of the broadening of the scope. So I'm not arguing for the removal of it. I'm just saying this is a consideration. So I'm not sure, maybe we should have a discussion on that on Tuesday, as well as possibly doing the planning meeting on Tuesday, depending on if our staff are able to help us with that. Thank you, Chair. Because that is a significant aspect. Thank you, Chair.
Thank you. I would really urge committee to that we do the planning next year. It would not be, I think it should not be the same as the other ones. we are starting a process of winding up a term. There is a lot of work, and I still need to meet with them to brief them about the things that should be contained in that report. So I would, in fact, plead with committee members to allow them time and space for next year. Honorable Silkstone, Ms. Silkstone.
Chair, what I could do is just before the end of term distribute to all the members a summary, a bit like the documents that we prepare every term, just to give members an idea of what they've covered in the last term. But I would appreciate if we had a bit more time to engage with you and around the needs of the planning of the planning session.
Okay. Honorable Neville Trojan.
Thank you very much, Chair. I doubt that we will finish this document by 2 o'clock. So could we perhaps continue with the hate crime, hate speech bill on Tuesday and Wednesday?
Yes. That is a suggestion. Can we, after we have just dealt with the procedural issues on the cannabis, can we proceed with hate crime, hate speech for Tuesday and Wednesday?
Okay, that's fine by me.
Thank you very much. Any objection?
Chair, I have a counter proposal. Can we then also adjourn earlier today? It's been a tough week.
Agreed, Chair.
Yes. Since we are going to be meeting on Tuesday, can we adjourn? Can we adjourn now so that Tuesday and Wednesday we deal with in fact we will start with hate crime, and then towards the end we can just deal with the procedural issues around the cannabis bill. Honorable
Chair, can I just raise an issue that's fine, but can we get a commitment from the members? Because what would be good is if we can work through the bill as we're doing now, but get to the end of it. I think it will go faster after the definitions. Obviously, there'll be some issues on the hate speech provisions, but can we get a commitment from the members to try and be able to complete the bill by the end of Wednesday so that the officials have then time to do the redrafting for the new year?
No, there's no reason for that. Chair, I'm sorry.
No.
Chair?
What we need to do is to process the bill to the best of our abilities. Let's not have a deadline, Honorable Deputy Minister.
Yeah, no, Chair, that's totally unacceptable. We will do our best, but we cannot have the executive asking us for a deadline when we're going to finish the bill. It's highly probable that it will be done, but I've never heard of that before. And the DM should know better. We've spent 8 years on some of the legislation previously, but I do appreciate what you have said, Chair. There's no deadline, but there's no reason why we shouldn't get through the bill in these 2 days. Thank you, Chair.
Chair, can I come back?
Honorable DM.
I'm not trying to issue instructions. I'm just, as you are aware, concerned about some members of the committee taking their time on this, including members who've indicated that they want to break now. But anyway, it's fine.
Chair, can I just, on a point of order, that is totally unacceptable, Chair. And I'm finding the Deputy Minister's comments unacceptable. And I would ask him to refrain from comments as to how we are doing our work. There's this continual pressure to finalize it, and we need to do it properly. And the committee, I had support from a number of members from the majority party. It's been a long week and there's no reason why we shouldn't adjourn now. Thank you, Chair. And I'd ask that you rule that the Deputy Minister is out of order. Thank you, Chair.
No, Honorable Hendricks.
I support the Reverend Swart. The executive took their own time to bring this to the portfolio committee, and now they want to rush us. And the Deputy Minister must not start and steamroller us. Who the hell does he think he is? Thank you very much.
No, thank you very much. Members, I don't think it's necessary. Also, the Deputy Minister has got his views. I think we can differ with his views, but I don't think that it is his intention to steamroll us. And we have made it clear to him that we are going to process the bill as we process all other bills. And we have to be efficient and all of those things, but we must ensure at the end of the day that we produce a bill that would, we can say that even if we can be wrong, but we can say that we applied ourselves properly. I don't think that we should go to, we should take it more far other than that. So I think that he was expressing his views, and we've got the right to differ with him. I would not say that I don't think that he wanted to instruct us. He was just presenting his own anxieties. We've got the right to say, no, we don't agree with them. Members, can we end here? And we meet on Tuesday at 9:30.
Chair Swatcha, I've just received the cannabis bill, and I think the legal opinion, I think we're probably going to need both Tuesday and Wednesday to deal with the cannabis legal opinion. Only Jacob, that's to my good friend, the Deputy Minister.
No, thank you very much. No, I can see that Honorable Swart is really hungry. Thank you very much. The meeting is adjourned.
Thanks, Chair.
Thank you, Chairperson.
Thank you, Mr. Chair.
Thank you.
Thank you, Chair.
Thank you.
Goodbye.
Bye-bye.